All right, I think other than that little bit of echo, which I can fix right here, we are all set to go. We have a plea and arraignment calendar this morning, and I think we are also going to talk about Mr. Sherman. Deputy Gordon and I were talking about that. I don't think he was brought over. You understand? Okay, great. So we'll talk about Mr. Sherman in his absence, but on the record. At the appropriate time. And I think we have at least one plea, maybe two pleas that we will work through in just a moment. But I have to make one change. All right. So let's get started. The first position is Fabian Spencer, and I see Mr. Wright on our, oops, where did he go?
I'm right here, Judge.
Hey, Mr. Wright, how are you doing? Just trying to get you spotlighted. There you are. Excellent. Where's Mr. Spencer?
Judge, I would expect, I haven't had contact since I went on medical leave with him. I did have Miss Rockwell covering for me a few times. So I'm not sure if he got notice. I would ask.
Maybe he just walked in. Are you Fabian Spencer? Well, the timing is just right. He just walked in the courtroom. So you can stop the song and dance routine of like, no, he's here. And he did get notice, which is great because this is a slightly older case that got sent to us from non-complex. So good morning, Mr. Spencer. I'm Judge McBurney. Your lawyer, Mr. Wright, is on the screen. You should be able to see him. He is appearing from his home office. You can learn a lot about someone. Looks like there's a nice porch. There's a flat panel TV mounted on the wall. He's got one of those gas heaters. We got to go over there for our next session. Anyway, you're here for plea and arraignment. You are charged with possession of a firearm by a convicted felon. Mr. Wright, are you going to be able to stick with Mr. Spencer in this case?
I will, Judge. I haven't had a chance to speak with Mr. Spencer, but assuming everything remains intact with our relationship, I will see him through on this.
Excellent.
Plea and arraignment, Judge, we would plead not guilty, request 10 days to file motions. This is right before my medical leave started. This case was supposed to go to diversion or be offered for diversion. So I'm not sure where things changed, but we'll get that figured out, I guess, over the next few days.
Sure. It went to non-complex initially based on the charges. And then at some point, they figured out the folks in non-complex, even though it sat there for a bunch of months. In October, there was a determination made that Mr. Spencer is a repeat offender. And they love finding that out in non-complex because then they get to transfer the case. And it hit the wheel and went to me. So we've got it now. Mr. Spencer, I don't know when you last spoke with Mr. Wright, but he was out of commission for a while on a medical leave. You can see he's back in action, and he's going to continue working with you. Good morning, Mr. Hand.
Good morning, Judge.
Mr. Wright is waiving arraignment on behalf of Mr. Spencer and is ready for the scheduling order to come out and all that. Any announcement from the state concerning Mr. Spencer's case?
Not only, Judge, that the state has sent initial discovery yesterday. And
okay.
Hopefully Mr. Wright received that.
Okay, this is what he did. Great. So the process is already underway. So Mr. Wright, my request to you is that you get one of our standard waiver of arraignment forms. I think it's on the website. Otherwise, you know Ms. Nelson, she'll get you one. Get that filed. That'll trigger a scheduling order to go out. And then there'll be a real clear path, whether there are going to be any motions or not. And this doesn't sound like the kind of case that's going to take a long time for the two sides to sort out, especially if it was trending in the direction of diversion in non-complex. It may have a different fate here, and that's entirely up to the lawyers to work through. But my hope is that it's the kind of thing that can be sorted out sooner rather than later. Mr. Spencer, just because it's been a minute, let me make sure we still have a good address. I've got you on Baker's Ferry Road. Is that still a good address for you? Good. You'll get stuff in the mail telling you when you need to be back here. Mr. Wright will also know, and he'll be reaching out to you, but the official notice will come in the mail to that Baker's Ferry Road address. So if you move, you got to let Mr. Wright know so he can get your address changed in the system. Any questions about anything? All right, Mr. Wright, anything else on behalf of Mr. Spencer?
No, Your Honor.
All right, so if you'll get that waiver to Ms. Nelson or e-filed, however you want to do it, that'll get this case moving.
I will do so, Judge.
Great, good to see you.
Good to see you, Judge.
Mr. Spencer, you are free to go. Do you, Mr. Wright, you have contact information for Mr. Spencer?
I tell you what, just out of an abundance of caution, if he could give me his phone number and I'll give him a call, make sure he has all my information.
You won't, no one's going to write it down. Say it out loud. It's okay. 470-257-2030.
Got it.
All right, you guys are connected.
All right, thank you very much, Judge.
You bet. Position 2 is Michael Harper.
Here, Judge.
Mr. Harper is here. Good morning, Mr. Harper. This also came to us courtesy of non-complex, another repeat offender situation. Mr. Harper, you are charged with possessing methamphetamine, few other offenses, driving while license suspended or revoked. That'll get you every time. Ms. Wood, is Mr. Harper waiving arraignment?
We are, Judge.
Okay, have you already done that or you will do it?
I will do it.
Okay, great. Anything else you need to share on behalf of Mr. Harper at this time?
No, Your Honor, he updated his address in Odyssey the first part of October. We have the contact information for each other, so.
Excellent. Okay, good. Mr. Hand, anything for Mr. Harper?
Just the initial discovery was shared yesterday, Judge.
Look at that. Nothing like the day before the calendar, but it's plea and arraignment. Mr. Harper, your lawyer is beginning to get the discovery in your case, which will be police reports, maybe body cam video, ultimately something from the crime lab, because there's allegedly drugs involved and they'll need to prove that it is what they say it is. Ms. Wood will be in touch with you. I will see you next, either because Ms. Wood has filed some motions on your behalf, maybe a suppression motion, something like that, or for what we call a status conference, which is the last time we'll talk before I see you for a trial. And at that status conference, I make sure your lawyer has everything she's entitled to, and maybe the case has been worked out and we take a plea then. Otherwise, I'll get your case on a trial calendar. You have questions about anything? All right. Ms. Wood, do you need Mr. Harper to stay? All right, you're free to go. I have an email about position 3. Let me see what that email said.
And Judge, Mr. Shapiro gave me the announcement for.
Good. I think, like I said, too, there is an email. Where did that go? All right. Mr. Huey, how are you, sir?
I'm fine, sir.
You'll be even more fine if you tell me that you got a lawyer. You were here a couple months ago, a month and a half ago, and said, I need to get a lawyer. There's still no entry of appearance in the docket. How are we doing with that?
I talked to Kim. She was telling me she was having me on my last case, not this one. And I want to speak on this case.
Okay. When you say your last case, is that other case resolved?
Yes, sir.
Okay. And when you say Kim or Ken, who are you talking about?
Somebody called up.
Okay, that's a lawyer?
Yes, sir.
That's someone who helped you with your other case?
Yes, sir.
Okay, and that's someone you paid to do that?
Yes, sir.
You're not in a position to pay her anymore? Okay, then what I'll do is ask Ms. Wood when we take a break. Are we going to have Ms. Feely here or you're flying solo today?
Flying solo.
Okay, when we take a break, I'm going to ask Ms. Wood to talk with you to see if you qualify for appointed representation. And if so, you've got a great lawyer sitting right there. She may not ultimately be your lawyer. She's got a partner. And depending on some magic formula, they assign cases between the two of them. But Ms. Wood can certainly figure out if you qualify for her office. So I'm going to ask you to sit tight. And during a break, the two of you can talk, and then please don't leave until you and I talk again. Okay. All right. What did you have to add, if anything, Mr. Hand? That Mr. Shapiro's notice was, hey, this guy doesn't have a lawyer. So I don't have anyone to give discovery to. Same thing. Excellent. All right. Michael Crowe.
He's on the Zoom, Judge.
He's on the Zoom. Which one is Michael Crowe?
The Nokia.
He's the Nokia. All right. Now he's right there. You able to unmute, Mr. Crowe?
Yes, sir.
Great. There he is. Excellent. Ms. Wood, when I say it's your office's case.
He's mine, Judge.
Yours. All right. Great. Another transfer from non-complex. It's early Christmas, thanks to non-complex. This looks like a resolvable case. Tell me what's going on with Mr. Crowe. Oh, this is one of our pleas.
Yes, sir.
It is resolvable. Excellent. Mr. Crowe, I'm Judge McBurney. We haven't met before. I didn't mean to not introduce myself. It sounds like in your case, there will be a plea. And we will do that in a little bit. Is this the gentleman who also has a CP case that's being dealt with?
Yes.
And has it been accused, or what's its status?
It has, Judge, and it has an SC number because of that. I can
Okay.
give that to you.
Yeah, why don't you give that to me and Ms. Rivers now, just so we've got it.
Yes, Judge, it's 22 SC 184895.
895. Excellent. So, Mr. Crowe, you are going to be able to go back on mute for a little while. We will indeed take the pleas in the two cases. We're going to do that in a little bit, maybe about an hour. So don't hang up or anything, but you can be at ease, and I'll make it real clear when we're back to your case. Okay?
Yes, sir. Thank you.
Thank you. All right. All right, Hezekiah Swanson. Is that your case, Ms. Wood? That's Ms. Feely's. How do you divide up, just so I don't have to always guess?
I have indictments ending in 0 through 4.
Okay.
And she has the rest.
So this would be Ms. Feely's case.
Yes.
We don't have a Mr. Swanson, unless he's online. I am not seeing a Swanson. This also says transferred. Let's see what's going on with his. Also from non-complex. Okay. Another meth case. All right. But not a repeat offender. It's the nature of one of the charges. Okay.
So we will reach out and see.
Yeah. This is old in the sense that Mr. Swanson had his first appearance in January of 2021, made bond. And so it's been almost 2 years since he would have had court contact. Let me see what we've got here. A Lithonia address. You're not aware that Ms. Feely has had any contact with him?
I'm not aware, Judge, but I did find a number, so we'll give them a ring.
Okay, why don't you do that during the break? Mr. Hand, bench warrant for Mr. Swanson, is that the?
Yes, Judge, the state would request it.
Okay, we'll see what can happen over the break, but I think that'll be the default. All right. Position 6 is Aquarius Hopkins. And I think I saw Mr. Hopkins on. Hey, Mr. Hopkins, how are you?
I'm okay, Judge. How are you doing?
I'm all right. And we've got Mr. Bennett back. There he is on the screen. Mr. Hopkins, it's a serious charge. Ms. Charles, your case?
Yes, sir.
Good morning. Good morning, Mr. Bennett. Is Mr. Hopkins waiving arraignment or are you seeking to withdraw, Mr. Bennett?
Unfortunately, Your Honor, I am. The
Okay.
scope of my representation of Mr. Hopkins was originally limited to preliminary hearing and bond, which is not something that I generally like to do. But in this case, we felt strongly that Mr. Hopkins was being falsely accused in this case, and we're willing to do a limited appearance. He was able to get a bond, but he wasn't able to continue to pay the legal fee. So for the remainder of the case. So based on that, Your Honor, I think he is going to qualify for indigent defense, and we are asking to withdraw on this time. I was kind of surprised that my entry followed to the SC. I was a little surprised, but I'm here, no problem.
Good. Yeah, everything that's in the world of CP moves over to SC. And as you mentioned, you're reluctant to have a limited entry. In general, we're reluctant to allow limited entries, and who knows what the dialogue was back in 2020. This alleged incident is really old. So it looks like Judge Glanville in August of 2020 granted bond. Given these charges, it would have been in front of a Superior Court judge. And then nothing happened with the case for literally more than 2 years. But your name stuck with it. So here you are.
You're right.
All right. So we got to talk through a few things. Mr. Hopkins, you understand Mr. Bennett's perspective that his firm believes that you retained them for purposes of bond and maybe a preliminary hearing, but nothing beyond that. Do you agree with that, or do you have a different recollection?
I wanted to continue to pay them, but due to the accusations, like the jobs that I have or had, it was hard for me to stay in the area of work. So it was hard for me to make money.
Okay.
And I tried to contact them a year ago and no one ever replied. So it was just basically miscommunication.
Okay. But it sounds like at this point, you're not in a position to afford their services. Is that a fair statement?
Yes, sir.
Okay. Then Mr. Bennett, I will allow you and your firm to withdraw. Can you get a proposed order? I don't know if it's attached to the motion to withdraw. If it's not, if you could please get a proposed order to Ms. Nelson.
Yes, sir.
Mr. Hopkins, you are entitled to a lawyer. You have a right to a lawyer. Any lawyer you can afford, and if you can't afford one, then a very able lawyer will be appointed to represent you. What I'm going to need you to do is provide a phone number so that Ms. Wood, who is here today from the Public Defender's Office, can give you a call this morning, so that she can talk to you about your finances and get a sense as to whether you qualify for her office's representation. And if the answer is yes, and it sounds like it'd probably be yes, then she and her law partner can step in and make sure this case keeps moving. Does that work for you?
Yes, sir.
Okay. What is a good phone number for Ms. Wood to call you on?
470-838-0761.
Did you get that, Ms. Wood?
Yes, Judge.
Okay. So, Mr. Hopkins, you can go back to, in a moment, being mute and no video. Expect a call from Ms. Wood in just a little bit when we take a break. But then I'll want you to come back on so we can reconnect and figure out what's next in your case, okay?
Okay.
Let me do a couple things while I remember. First, the address of record for you is a Carriage Place court address in Decatur. Is that is still a good address?
No, sir.
Okay. Well, that'll be enough. If Ms. Wood is going to be working with you, we'll need to get a new address for you. How'd you learn about today's hearing?
The attorney.
Oh, Mr. Bennett reached out to you.
Yes, and the
Okay.
pretrial service lady.
Oh, okay, the good old pretrial service lady. Excellent. They do their job well. We'll need to get that new address from you, but we'll do that through Ms. Wood. And then the other thing, I just wanted to make sure your bond. Are you still wearing an ankle monitor?
Yes, sir.
Are you having to pay for that, or is the county paying for that?
I'm having to pay $300 a month.
Okay, well, that'll be another thing then that we'll want to talk about, because you've been wearing an ankle monitor for 2 years. Query whether that is still the highest and best use of an ankle monitor. So that's topic number 2, address and ankle monitor. But I'll have Ms. Wood reach out to you during the break. Mr. Bennett, you are free to go. You owe us a proposed order letting you and your firm withdraw, okay?
Yes, sir. I believe it is attached to the motion, but if y'all need me to submit one in doc format, I'd be happy to.
Nope, if it's on the motion, we're good, and I will take that from there. Mr. Hopkins, you should stay on the Zoom, but you're welcome to go back to mute and no video. Yes, ma'am. Off to Judge Cox. Good morning, Mr. Whitenauer. Next up is Linda Seals.
She's present.
Hello, Ms. Seals. How are you? Okay, well, you're here. That's a good sign. This is Ms. Feely's case.
Yes.
Ms. Wood will be handling it today. And Ms. Seals, you were charged with terroristic threats. Ms. Wood, is Ms. Seals waiving arraignment?
We are, Judge.
Okay. So you'll get something filed. We'll get a scheduling order filed. Mr. Hand, will this be your case?
It will be, Judge.
All right. Anything we need to cover right now from the state?
No, Judge.
Discovery has either just been sent or will be soon.
Just been sent, Judge.
All right. So Ms. Seals, what'll happen next is that Ms. Feely, who's not here today, a colleague of Ms. Wood, will be reaching out to you. Have you already spoken with her? No? Do we have good contact information for Ms. Seals?
I'm gonna double check that I have her good number, but I just gave her all of Miss Feely's
Excellent.
information.
So you've got a way to reach Ms. Feely. She's going to want to talk to you about your case, hear from you all about it. She's also going to look at the discovery to share with you what the state thinks the case is about. Just looking at these charges, my guess is that this is one that will resolve short of trial. But if it doesn't and you want a trial, we'll try to make that happen as soon as we can. But Ms. Feely needs a chance to look at the discovery, understand what the case is all about. And then confer with you so you can benefit from her advice and she can benefit from your firsthand knowledge about what happened in this situation. I'm going to quickly look your case up here to make sure we've got a good address in the system for you. Are you still on Ben Hill Road? Good. So you'll get stuff in the mail from us telling you when to be here, but Ms. Feely will be contacting you as well. Mr. Hand, anything else in Ms. Seals' case?
No, Judge.
All right. Do you need Ms. Seals to, you're going to exchange?
I'm just gonna pop back there, Judge, but
Okay.
otherwise she's free to go.
All right. You can leave Ms. Seals once Ms. Wood gets you this information. All right, next up is Mike Tate. Good morning, Mr. Smith.
Good morning, Judge. Sorry I was late this morning.
You're right on time because this is the first time I call Mr. Tate's name, who is here standing behind you. Hello, Mr. Tate. Good morning. Who has this case for the state?
I do, Judge.
Hey, Mr. Whitenauer. All right. Mr. Smith, is Mr. Tate wanting to be formally arraigned or is he waiving arraignment?
Thank you for asking. I think he needs to inquire of the public defender simply because I filed a motion to withdraw.
Oh,
I was hired for purposes of bond only.
we had a couple of these today.
And I had an attached order to it.
Okay, let's look it up.
Morning, Ms. Nelson.
She says hi remotely.
Oh,
Good morning. Good
There we
morning.
go. Okay, yep, I see a motion to withdraw that was filed about a week ago. Is there an order attached to it?
there is.
Okay, so your situation is sort of like Mr. Bennett's. You assisted Mr. Tate. And this is very similar to Mr. because it was 2 years ago. You assisted Mr. Tate in obtaining a bond, maybe a prelim, but that work was finished almost 2 years ago. Okay. Mr. Tate, is that your understanding of the business arrangement you had with Mr. Smith? He helped you for that discrete project of getting you a bond and you haven't paid him for additional services. Is that correct? Okay. Are you in a position to continue to retain Mr. Smith, or would you like to talk with Ms. Wood about getting appointed counsel?
I'm tired of giving money to check, so no money, like giving a check, they won't fee a tax. And besides, I lost my mother a couple months ago.
I'm sorry to hear that. Okay. It sounds like it would make sense for you and Ms. Wood to talk because you have a pretty restricted budget. So I'm going to ask you to stay, and Ms. Wood will talk to you in the break that's just about 5 minutes away to see if you qualify for appointed counsel. And if you do, then looking at the number of your indictment, Ms. Wood will actually be able to help you directly as opposed to get her partner, her law partner, to work with you. And we'll figure out what we're going to do today. Today, it's formal, you're in court, but what we're doing is just procedural. You're either being read your charges in court or you're waiving that and in saying at this point, not guilty, and then we can move your case along. But you need a lawyer to walk you through that process, and it's not going to be Mr. Smith. Sounds like it'll probably be Ms. Wood, okay? But while I've got you here and I'm remembering, let me make sure, since so much time has passed, the address we have in the system is an address on Shirley Street in Atlanta. Do you still live there? Great. All right. That's where you'll get things about this case. They'll be mailed there. Okay. Mr. Smith, I have not forgotten the other matter that you and Mr. Hiles left with me. I'm not ignoring it. I'm marinating on it, but it will likely happen this week.
I'm going to email over to Mr. Hiles to see if he is okay with me addressing just a couple of small matters.
In connection with that, is it modifying something or?
No, I didn't have a chance really to ask the court if they had any additional concerns of me, just because I had 9 things going on.
You did. No, Ms. Rockwell was there, which was good. Your client's interests were protected, but it was Mr. Hiles doing all the talking, but it was real helpful. The primary thing he shared was the fundamental reorientation of the state's theory because it was front to back and not back to front, and that the geography changes everything.
It does. And then I thought there was maybe just a couple of additional things I could probably tack on that might be helpful for the court in making that decision. Okay. Which
you're welcome to. I don't know what your schedule is. We're going to have to pause for a little while in about 5 minutes. I just need to get through the calendar and then we're going to pause. So I'm happy to chat. We could just, one of the ADAs could stick around. We don't need to just chat right here or something. Okay. All right, Mr. Tate, you don't need to keep standing. Thank you. Ms. Wood will talk with you in just a minute. Okay. All right. 2 left. Mr. Briskey, Eugene Briskey.
Judge, I've reviewed Odyssey and it appears that a waiver to enter not guilty was filed in that case by defense counsel.
Okay. And is that Mr. Mitnick? Is that his counsel of record?
Yes, Judge.
And this is your case?
It is, Judge.
Is there a charge I'm missing, or it was a burglary of a loved one?
Civil battery and family violence, Judge.
Oh, okay.
One of the victims was previously in a relationship with the defendant.
Okay.
I would tell the court, Judge, that while we do have some of the discovery, some portions like body camera and Written statements are outstanding. I requested those and I received will serve those on defense.
Okay. That's helpful to know. Let Mr. Mitnick know that there's a lag in that. Is it it's not APD, it's a smaller agency? Okay, well, I'm guessing you'll get it soon then. So if Mr. Mitnick waived arraignment for Mr. Briskey, then Ms. Nelson will get that scheduling order out. You look.
Sorry, I think actually maybe Alpharetta. Nonetheless, Alpharetta is good. It should be a problem.
Good. Okay. Alpharetta is good, he says. So we'll get the scheduling order out. That'll give you a deadline to get that last bit of discovery. If you can't meet it because Alpharetta is bad, just let Mr. Mitnick and Ms. Nelson know, and we'll keep the case moving along.
Yes, sir.
All right. Arian Kelly.
Judge, she's on the Zoom. I believe.
She is. Okay. Yes, she is. Let's.
Yes, I'm here. I'm trying to turn on my video now.
Okay. There you are. All right. We've got you, Ms. Wood. Let me get you on the screen so she can see you. Great. Good morning, Ms. Kelly.
Good morning.
Ms. Wood is here in court. You are appearing remotely. This is an arraignment in your case. Ms. Wood, is Ms. Kelly waiving arraignment?
Judge, I spoke with her yesterday. She told me she plans to hire. So I think.
Can you turn, I don't know if your microphone is on, I'll make sure she can hear you. There we go.
Yes. So I spoke to her yesterday. She told me she intends to hire private counsel. So
Okay.
this might need to be reset.
Well, let me talk with Ms. Kelly about that. Ms. Kelly, you are free to hire a lawyer. If you cannot afford one, then I'll appoint one for you. It would be the public defender. That's the default, the very effective default that we've got here. Do you feel like you've got sufficient finances to hire someone?
Not right now, no, Judge.
Okay. So when you were talking with Ms. Wood, was it your thought that someday down the road you might hire someone, but as of today, which is when we need to start talking about your case, you're not in a position to hire someone?
No, I was looking because like the lawyer that I was looking at, the price was pretty high. So I was thinking like within the next month or two. I actually didn't know that because I just heard about today's court date yesterday. So I thought that I had more time. But
Okay.
with 3 felonies, I don't want a public defender.
So public defenders handle murders and rapes and child molestations. And I'm looking at yours. You actually have 2 felonies and 1 misdemeanor in the indictment. And I know they seem serious to you because it's your life, and felonies are serious things, but in the grand scheme of things, they're not all that serious. And Ms. Wood and Ms. Feely routinely handle rapes, murders, armed robberies, et cetera. So this is not anything that is beyond their scope, but it's not my job to convince you one way or the other. You've got 2 options. We really have 3, but one of them is a really, really bad option. You can always hire someone. If you are not able to hire someone right now, then I'm going to appoint the public defender to represent you. You can change that arrangement whenever you are able financially to do so. That third option is you can always represent yourself. But we have to have a whole hearing about that. And I didn't hear you say anything that suggested that that's what you want to do. You want a lawyer, and it sounds like you'd prefer to have one that you pay for. But right now you cannot afford one. And so it sounds like the public defender ought to step in and begin to move your case along. Does that make sense?
Yes.
Okay. Who was the lawyer you were talking to?
Miss Woods. Oh, you talking about my lawyer?
Yeah.
Oh,
You said you talked to someone and I'm not going to have that much money, maybe in a few months.
Oh, yes. His name was Henry Williams.
Okay. You said that you heard about this court appearance only yesterday. How did you learn about it? Did Ms. Wood give you a call?
My mom, I guess she left a voicemail on my mom's phone, and my
Okay.
mom sent it to me.
Got it. Well, thank you to your mom. The address that's in the system for you is a Windcliff Drive address in Marietta. Do you live there?
Yes, I do, but I'll need to update it because I'll be moving in 1 week.
Okay. Well, what I'm going to have you do is talk with Ms. Wood. Do you now have a direct line for Ms. Kelly, or do you need to get that?
I do, Judge.
Okay, so we're going to take a break once you and I are done chatting, Ms. Kelly. And I'm going to have Ms. Wood give you a call at the number she has for you. You can give her that new address. She may need to talk to you a little bit more about your financial situation, because if Mr. Williams, I think that was the name you gave, was asking for $1 million, you may actually have plenty of money to hire a lawyer, just not Mr. Williams. And if you've got too much money, then it's not appropriate for the public defender to represent you. They are plenty busy with folks who've got $0, and they're helping them with their very serious cases. So Ms. Wood's going to need to talk to you about finances, and then make sure she gets your new address so we can get that into the system. And then the three of us will talk a little bit more about how to move your case forward. Okay?
Yes, sir.
Mr. Hand, will this be your case?
It will be, Judge.
All right. Then we will talk with Ms. Kelly again. We're going to talk with Mr. Tate again. Mr. Huey hopefully is still here. Maybe he just.
Speaking with my intern, Judge.
Oh, good. Okay. And Mr. Hopkins. So you've got a few conversations to have, but we've got a break. Let me let Mr. Barron know. I think that's the name. Are you Mr. Barron? Is that right? In the wood panel basement again?
Correct.
Excellent. So Mr. Barron and Mr. Crowe, we will be taking your pleas in about a half hour. So you can be at ease. I'll get back on and you'll know it's going, but between now and then, just at least have the audio of your device on, so that we can get your attention when we are able to get back in session. Okay?
Yes, Your Honor.
Excellent. And I will take you off spotlight, Ms. Kelly, and you can chat with Ms. Wood. I think that's it for this. Oh, we have Mr. Sherman to talk about as well.
Yes.
Why don't you, Ms. Wood, talk with these folks first, because some may be able to, if you're going to be able to represent them and they want to waive arraignment, we can move them along. We'll still talk about Mr. Sherman. We'll still take Mr. Crowe's plea, and we'll take Mr. Barron's plea. We'll probably do Mr. Crowe first, unless you all tell me it needs to go the other way around.
That's fine, Judge.
Okay. All right. I have something for Mr. Cotton, which I will get. And then Mr. Smith, if you can grab one of these ADAs, why don't we just go into the jury room? I'm going to come back out to give something to Mr. Cotton, and then we'll just go into the jury room. Okay.
Tate.
Yeah. Cool. Is there another Crowe?
Yeah.
Oh. Oh. History.
Really appropriate. I appreciate it. Bet you learned. It's a New York Times, investigative journalist just came out. He,
Oh, yeah, I'll do this.
yeah, oh yeah, it goes deep into how they got there and the interplay, and it's not like positive for them. It's, yeah. I think it really.
This is still read online.
Specifically on land, like all of this. Yeah. Hey, stay for the meeting. The judge is gonna pull us to the side. Reese has no issue with me talking to the judge. Just in case the judge has any questions or make sure I don't say anything. And then you want to be fair.
That's right. So I just sign it right now. You're right here. There's no.
You don't have to say.
Don't bring all your. We did that one yesterday.
Oh, really?
In anticipation. Yes.
Oh, okay.
Oh, nice man. No, he said it's okay. I'll speak to him with one of the DAs.
I did say that.
No, the Reeves did as well, Judge.
Oh, okay. Because he had a field day. I mean, he got to talk on and on and on. Renee was sitting there, but Renee didn't know anything about the case. She's like, what? The head was going in that direction? Good luck with everything.
And Renee didn't say anything, so.
I mean, she knew what we were talking about, but she's like, I'm just here in case Reeves suddenly starts saying something crazy. It was fine, but let's go talk.
This is Investigator Miller. He's not a prosecutor.
Thank you, Your Honor.
Right. Oh, did you grab any?
I did. Let me go grab one there in the
Okay.
hallway.
Right. Yes, sir.
Hey, Mr. Judge, my name's Jerry Huey.
I know who you are.
Yes, sir.
I just was up there before.
Yes, sir. I had a good work there. I just started doing that 5 6 days at Harrison and Davis on Welcome Road. And I called out for a couple hours today. I smoked 3:30 till 11. Second shift. And I was just hoping how long this process will take.
So it won't take, have you spoken with Ms. Wood yet?
I don't know which one is good.
Okay, well, sit tight, because you disappeared on us.
No, I spoke with the one.
Oh, you spoke with her intern?
Yes, sir.
Okay, then you're good. She's just we're taking like a 10-minute break.
Oh,
You'll get out this morning.
oh,
You will be gone before 10:30.
because I caught the bus this time.
All right.
No, you said you should talk. What, sorry. I'll let you.
Thanks for doing this.
No, I think fine. I think fine.
How do you, I was not setting you up, JP.
Oh, I didn't, because I was pretty sure the parameter is clear.
Okay.
So I got all three cases there. I don't think it's that there. So,
Okay. I think we talked to you last time on this one. That's a question. How do you- Okay. Okay, 937. Okay, is this your direct one? Yes. Okay. Okay. Yeah. Okay. Got it. Alright, so what I'll do is judge. So just keep my contact information. Okay, all right. Okay. Yes. Thank you, sir. Where did Mr. Huey go? You didn't tell me anything. Let's go see if he's in the hallway.
All right, thanks guys. Thank you.
Mhm. Right, I know, that's what I was thinking. No, I think that's right. Mhm. Okay, thank you.
I think it can be here. My vodka. Well, come on, they have higher real estate values. All right, let's see how we did with representation. I'm just going to go in the order of the calendar. Mr. Huey, still here. Ms. Wood, what, and thank you for assisting Ms. Wood, Ms. Intern. I forgot your name, I'm sorry. But I'm going to probably introduce you in a little bit. Tell me your last name again.
Evans.
Evans. Okay, I'll be able to say that. Thank you for helping, Ms. Evans. What's the word with Ms. Huey, Ms. Wood? Mr. Huey, Ms. Wood.
Qualifies, Judge.
He qualifies. All right. And it's a 3, so it's your case?
Yes.
All right. Mr. Huey, you met with, I know you met with Ms. Evans. Did you also connect with Ms. Wood? Okay. Will you be filing an entry of appearance?
I will, Judge.
All right. And waiving arraignment?
Correct.
Excellent. Waive and schedule. And Mr. Huey, you got notice to be here in the mail. How'd you know to be here today? Okay, so we still have a good address for you. Right, you don't, wherever, as long as you got something in the mail, then the system is sending it to you because it's automated. I don't hand type it. Is this a Mr. Hand production?
No, Judge.
This is Mr. Shapiro's case. Got it.
Will it be Ms. Feeler or Ms. Wood?
Ms. Wood.
Wood.
It's a 3.
Okay.
So, Mr. Huey, here's what's going to happen next. In a couple minutes, you're going to leave, but in a slightly longer term, Ms. Wood is going to file a couple things on your behalf, which will trigger the state providing all the discovery it has, police reports, if there's body cam video, all that stuff will go to Ms. Wood. She'll review it, and then she's going to want to meet with you to talk about the case. Give you her sense of, oh, these look like pretty serious charges, and here's this evidence, or hey, you know, this doesn't even look like you on the body cam, and you'll be able to talk to her about whatever was going on. She'll file motions if there are motions that need to be filed in your case, and then we'll meet again. The first time you'll need to come back to court will either be for those motions or for what we call a status conference, where I make sure all systems are go. If the case isn't working out, then we get you onto a trial calendar, okay? Your number one job is to stay in touch with Ms. Wood. If you move, if your phone number changes, anything like that, you got to let Ms. Wood know. Because if you miss court, then I got to sign a bench warrant and we have to redo all this stuff. You're going to get scooped up. It sounds like you've got a good job now and you don't want to mess with that, okay? Any questions? Do you need Mr. Huey to stick around anymore? All right, you're free to go, sir. All right, let's then turn to Mr. Hopkins.
Judge, Mr. Swanson is on the call now.
Oh, okay. We're not there yet. Oh, we are. You're right. It's just before. Okay. Mr. Swanson, can you make yourself appear? There he is. All right. Whoa.
Hey, how are you?
You still there, Mr. Swanson?
Yes, sir.
Okay. Let me cross out this bench warrant situation. Mr. Swanson, did you have a chance to, Ms. Wood, did you have a chance to talk with Mr. Swanson?
I did not, but my office did.
Did. Okay, great. How'd they track you down? Yes?
I didn't get a chance to speak with your office, Ms. Wood.
Did you just get a call from them, or how did you know? Like, you're on the phone now. How'd you know to join this call?
I got a text message to join the Zoom meeting, but I didn't actually get to talk to anyone. I was just saying that. That's all.
Okay, got it. Well, Ms. Feely, who is not in court today, she's going to be your lawyer. She's going to reach out to you. Do we have a good phone number for Mr. Swanson, or should we get him to tell us?
Does it end in 0863?
That's my mom's cell phone number. She notified me of the meeting this morning because I think maybe we checked the mailbox last night. Mail ran too late. I didn't get the letter. So when the court clerk called my mom, she notified me to get on the Zoom.
Well, we need to get a good phone number for you. So why don't you tell Ms. Wood what that is?
It is 470-920-5201.
5201?
Yes, Your Honor.
All right, and that goes to you, not to your mom or your uncle or anyone else?
That's my cell phone.
Excellent. And in terms of address, the address we've got in the system for you is on Fields Drive in Lithonia. Is that where you live?
Yes, Your Honor. 2966 Fields Drive.
Oh, we have 2996. It's 2966?
Yes, Your Honor. It's 2966.
Okay. Well, we'll get that corrected to 2966 Fields Drive in Lithonia. And you'll get things in the mail telling you when you need to come back to court. But importantly, Ms. Feely and you will be talking soon. She's going to get the discovery in the case and talk to you about her thoughts about the case, get input from you, and then she'll file motions if there are any motions that need to be filed, and we'll get you back into court. Okay?
Yes, Your Honor.
Ms. Wood, anything else we need to do in connection with Mr. Swanson? I guess I should add, are you waiving arraignment on his behalf at this time?
Yes, Judge.
All right. So we'll get a waiver filed, a scheduling order entered. Discovery will go to Ms. Feely, who will reach out to Mr. Swanson, and we'll correct his address to 2966. All right, great. Mr. Swanson, you have any other questions?
Just I would like to speak with my attorney afterwards, so we could, because I just want to know who I'm going to be talking with, who I'm going to be, who's my counsel is going to be, so we can discuss the case. So if she could just give me a call so we could,
Sure. So either Ms. Wood or Ms. Evans will give you a call this morning just to touch base. Neither one of them is the lawyer who will actually be working with you. That's Ms. Feely, and she's doing something else this morning. But these two women work with her, so they'll call you, answer whatever questions you've got, and then ultimately Ms. Feely will call you at that 5201 number, and then you and she can start the whole lawyer-client relationship, okay?
Yes, Your Honor.
All right. You are free to go. Ms. Wood or Ms. Evans will call you at that number in a little bit, okay?
Thank you, Your Honor.
All right, bye. So no bench warrant. We'll do the waiver. You'll file the waiver. We'll do a scheduling order. And then will you do an address correction also, please? Yes. Thank you. Just one digit. All right, now let's get to Mr. Hopkins. Mr. Hopkins is back. There he is. So Ms. Wood or Ms. Evans, did you have a chance to talk to Mr. Hopkins about representation?
We did speak to him, Judge. He's gonna qualify, and I also think I need to do a change of address for him in addition to the waiver and entry.
Okay. He'll ultimately be working with Ms. Feely, but
Yes.
for today, you will handle the waiver and the change of address.
Yes.
And you've got the address information from Mr. Hopkins already?
I think we did get it, Mr. Hopkins.
No, not yet.
My apologies.
That's okay.
Can you repeat it for me?
1415 Winchester Trail,
Is this on?
Atlanta, Georgia, 30339.
Thank you so much.
So Mr. Hopkins, Ms. Feely will be reaching out to you soon. She's not in court today, but she's Ms. Wood's law partner and is the one who will be handling your case going forward. So she'll get discovery from the prosecutor who was in here earlier today, and then start talking to you about the case. All right?
All right.
And I'm going to enter an order that gets Mr. Bennett off the case. So he won't be calling you anymore about court dates. It would be Ms. Feely. But more importantly, if we've got the correct address for you, you'll get things in the mail telling you when you need to be here next.
All right.
All right. Anything else?
Nope, that's it.
Okay. Ms. Wood?
No, Your Honor.
All right. You're free to go, Mr. Hopkins.
All right, thanks.
Sure. Stay awake. You guys don't have to pack together quite so much. There won't be other people coming into court. So if you want to spread out a little bit, you're welcome to spread out rows or just the real estate you've got currently in the rows. I don't know what Mr. Zeff told you, but classic school bureaucrat. Mr. Tate, how are you, sir? Why don't you come around and sit between Ms. Evans and Ms. Wood, please? All right, Ms. Wood, did you have a chance to speak with Mr. Tate?
I did, Judge.
And does he qualify?
He does.
All right, I will enter an order that allows Mr. Smith, who has since left, to withdraw, and you'll file an entry. And is Mr. Tate waiving arraignment?
We are, Judge.
All right. And Mr. Whitenauer, have you already sent discovery, or you may not have even known to whom to send it because of this lawyer transition?
Correct, Judge, because there was no entry and not yet served discovery.
Okay, you'll get it to Ms. Wood, and then Ms. Wood will be in touch with you, Mr. Tate, as long as you've given her good telephone information. I confirmed your address, so I know we'll be able to get you things in the mail. The only thing you'll be getting from the court, though, are invitations, but they're not really invitations. You have to come to court, okay? And just stay in touch with Ms. Wood if you've got questions about what's going on.
Do you have any questions? Okay.
All right, is that it, Ms. Wood?
That's it, Judge.
All right, Mr. Tate, you are free to go.
Just keep my number. Me too. Thank you.
And Ms. Kelly. There she is. Welcome back. All right, Ms. Wood, did you and Ms. Kelly have a chance to talk?
She did speak with our office. She does qualify. I will get the appropriate paperwork in. We will be waiving formal arraignment today, Judge.
All right. So Ms. Kelly, like you and I discussed earlier this morning, for now, Ms. Wood is your lawyer, your attorney of record. She's going to file an entry of appearance. So anything that's going to happen officially with your case would go through her. You are free in the future if you decide that that's how you want to spend your money. If you are able to raise enough to hire a lawyer, that can happen at any time. The one thing you need to understand is that if your case has moved along far enough that, let's say, and I don't know how it's going to play out, so just pretend with me, it's on a trial calendar. If you walk into court with a new lawyer, I'm not necessarily going to tell that new lawyer, oh, you can have 6 months to get ready. You'll need to let that lawyer know, hey, I'm actually about to go to trial. That lawyer may say, that's going to cost you more. Or that lawyer may say, I can't parachute in right now. Ms. Wood is ready to go to trial. I'm not. I'm a new lawyer on your case. So if you are thinking about transitioning, the earlier you do that, the easier it is for that other lawyer, and often the less you have to pay for it. And I share that with you not because I think you need to change anything at all. You've got a great lawyer now, and you may conclude that Ms. Wood is the right advocate for you. I just want you to understand, since you shared with me that you might be hiring someone, that you are free to do that. No one will say no, but that will not be a reason to delay things, okay?
Okay, yes, sir.
All right, any questions about that?
No, sir.
All right, then Ms. Wood's going to file some paperwork on your behalf. Mr. Hand, the prosecutor, is going to get the discovery to Ms. Wood, and then you and Ms. Wood can start talking about the case.
Okay, yes, sir.
And you've got all the contact information you need for Ms. Kelly?
Yes, Judge.
All right, Ms. Kelly, you are free to go. Thank you so much.
Thank you. Have a good day.
You too. All right, we have three things left. We have I think we have three things left. I know we have Mr. Crowe's pleas. We have Mr. Barron's plea. We also need to talk about Mr. Sherman. And we can, if we're going to do pleas first, we'll start with Mr. Crowe. Do we want to talk about Mr. Sherman first, or do we want to table that and see how we do with the two pleas?
If we could discuss Mr. Sherman first, his parents are actually here.
Okay.
And I don't think this will take all that long.
All right. Why don't we get on the record? I know Mr. Sherman's not here, but I think in some ways that's all the more reason to get on the record. You ready, Ms. Rivers? All right. So Mr. Sherman has two cases, 22 SC 182498 and 22 SC 182500, both charge Mr. Sherman with family violence battery. And my understanding is that in one of the cases, at least, Mr. Sherman's brother, who is now deceased, was the victim, the alleged victim. I think you pointed out, Mr. Hand, or a colleague of yours did when we were last talking about this, when Ms. Wood was saying, or someone was saying, these cases should go away because the victim is deceased. One of the cases, maybe it's one of Mr. Sherman's parents, maybe someone here in court, who is the alleged victim. So it's not just his sibling. Is that correct?
That is correct, Judge.
Okay, got it. Mr. Sherman came to court a few times, and I've told him this, so I'm not saying something that he would be hearing for the first time. He had some strange explanations about what's going on in his life and other cases he might have. At one point, he showed up and it looked like there were active warrants for him, so we had to have him in the jury box. And it's always been a little less than clear from Mr. Sherman. And then he missed court. And so he is in custody for having done that. He appeared virtually last week to talk about a few things and became very, very emotional when we got into the subject of his brother passing away. But we weren't in a position to talk about lifting the bench warrant, I think either because the state wasn't on notice we were going to do it or whatever reason. But we're doing that now. Mr. Sherman is not here, and he has affirmatively waived his presence. Is that correct, Ms. Wood?
Yes, Judge. I saw him Monday at Rice Street, and he asked me to go ahead and waive his presence for today's hearing.
All right. So tell me then, please, why you think Mr. Sherman would show up next time if he were released.
Well, Judge, I don't know if the court recalls, part of the issue was that he did not qualify previously before the arrest. I remember specifically qualifying him and understanding that he made more money than would qualify him. And so we kept resetting the case. Now, since he has been incarcerated for 37 days, he's lost that employment and he is able to qualify for our services. So now I would be able to have that direct contact. I know that the clerk mails notice, but often my clients find out about court from my phone calls or my emails or my text messages. I have spoken to his parents. They are fine if the court sets aside the bench warrant and reinstates the bond for him to come back and live with them. That's where he was living prior to
He
arrest.
would live with his parents. And is that consistent with, we'll have to look at the bond? Because if I need to modify the bond to do that, I wouldn't want another judge saying, I told him to stay away from his parents.
And Judge, I also have been looking for a bond order, and I'm wondering if it's because these were state court cases, if that's why I don't see one.
And that part of the docket wouldn't slide across.
Right.
Okay. Yeah, it's just an indictment. Okay, well, then there's less, I guess, we need to worry about. If we don't know it, we'll just claim we were ignorant of it. So your request is to simply reinstate the bond, allow Mr. Sherman to return to his parents' home. What is the state's view on it? I don't know if you've had a chance to speak with Mr. Sherman's parents.
I have, Judge. I've
Good.
speak with them just before we had our conference in there. Judge, from my conversation with the parents, this is an incident that one of the incidents, position 2, occurred in 2020, August of that year. It spanned 3 days. One incident where he got into it with his brother the first day. The state is understanding that his brother recently passed, and is understanding that may have changed the dynamic of the family situation as well. And it's an unfortunate happening. However, he did hit his brother on that day, August 6th. He fled. The police came to the home. He was nowhere there. He came back the next day. They called the police. He was apprehended that day. He was let out. He came back to the home on August 10th. Jamie Sherman, who's a father, allowed him into the house to get some items. They got into an argument. He pushed him against a wall.
Jason, pushed his father, Jamie.
Yes, sir.
Okay.
And so the police have been to the residence multiple times. This is just the incident that we're here on today. Even position 1 occurred at the residence. Both brothers were living in the home at the time. Judge, the state is just not comfortable with him returning to that home, being that multiple batteries have occurred there, or at least alleged batteries. And so the state's position, after speaking with the parents, because he has nowhere else to go, is no bond, Judge.
Okay. Mr. or Ms. Sherman, is there anything you want to add? Your view on this is instructive, because it sounds like you are willing to offer up. You don't have to take his phone, Deputy, but he's on notice. All right. Sir.
Mr. Sherman, I'd just like to say that we kind of do need him in our facility, because I'm 72 years old and I need him to get around the house there, because my mother, she passed away back in June, and then the whole son, he passed away just in October there. We just kind of need him to kind of be around the house there, but he needs to have some kind of management class, course to take. And
When you say management, like anger management?
mental or something.
Okay.
We need to try to get him, some kind of facility that would, give him that kind of, service.
Are you not concerned that if your son returned to your house, if he's not under the care or supervision of someone who either could counsel him or maybe provide some medication that might stabilize his moods, are you not concerned that he could get rough with you again? As you pointed out, you're not as young as you used to be, and it takes one little fall and then there's a broken hip or something kind of serious.
I understand this. I'm not, like I said, I'm not, really, afraid of that kind of incident. But I trust him,
Okay.
We need, like I said, medication, something to stabilize him.
What about your wife? Good morning.
Good morning. I feel that he do need some mental help, because he was diagnosed that he had a little mental illness going on from the last time he was in jail.
Mm-hmm.
So we was in the process of getting him that help when this came.
Okay.
An appointment for a field psychiatrist, and he agreed to see one. So we was in the, really trying to get all that done. But I would accept him back in the house, but with anger management, he needs anger management, mental.
Okay.
He needs some counseling.
Got it.
Because his brother, my oldest son that just passed, he was just like Cain and Abel, they always into it.
Yeah.
All the time.
Yeah.
He's not there. So I do feel like it would be better, for that position, because they just, like boys, they always argue back and forth.
Sure.
And Jason wasn't always in our house. He was out married, had his own house for years, but the divorce brought him back to us.
Okay. So it sounds like you are willing to reopen your home to him. You have some concerns about maybe his mental health and overall well-being. And if I were to modify his bond, we may just have to set a new bond because I don't know that we can find this state court bond. If one of the conditions of bond was that he begin treatment, you'd be comfortable with that? Or would you prefer that he not move back in until he has begun to receive treatment?
Well, if he get treatment in jail, that's what you're saying?
Well, that can start there. It's not usually as effective and as comprehensive as treatment one might get outside of jail. He'd first have to be evaluated. You know, really the first step, it's not enough that mom knows best, but it's not enough for mom to say, hey, he needs some help. You know, a psychiatrist would need to evaluate him. It sounds like that may have already happened before, and pretty quickly a course of treatment could be put into place. I just wanted to know your comfort level of letting that happen after he'd moved back, or if that would be a precondition, and then we just need to see how we could make that happen. It could take a while, in which case your son Jason would still be in the jail while we're trying to do that, and not able to help around the house, but he might get out a little more stable if that was already in place.
Yes, we really need him. We'll put him down because emotionally and physically we are really not able to do. He did most of all the yard work, the cleaning, and even the cooking most of it he did.
Is he a good cook?
Yes.
Oh, no wonder you need him back. All right. Tired of your husband's cooking.
Yes.
Okay.
You know, I would rather for him to, you know, be back with us.
Okay. It's real important that you were here. I appreciate you coming. I don't know how easy it was to get down here, but it's always more helpful to hear directly from the folks, because I very much appreciate what Mr. Hand, the prosecutor, had to say. I appreciate what Ms. Wood had to say. Neither one of them will be living with Mr. Sherman after today, and you will. So hearing from you was important. Thank you. All right. So Ms. Wood and Mr. Hand, I'm inclined to set a new bond, just sort of wipe the slate clean of the old bond, the conditions of which we don't know. One of the conditions was probably stay away from the deceased. We don't need that anymore. His brother's deceased now. But what I would likely include would be a requirement that Mr. Sherman, within the first 2 weeks of release, figure out how to get an evaluation, whether it's 10 Park Place, if he can't afford something through insurance, but somewhere get that evaluation so that a course of treatment starts going. It would be through pretrial supervision. So I don't know if they can help someone get into anger management courses, but we have of late been loading up bonds with conditions that you would normally see in a sentence, because we have a lot of cases that haven't been indicted, and it's a way to get someone out and getting the help they need that they're not getting in custody. Mr. Sherman seems like a good candidate for that. He was on bond for 2 years before these indictments happened. And it wasn't new activity other than he missed court. So I'd ask you, Ms. Wood, to confer with Mr. Sherman's parents about a dollar amount through the 10% program that could be made. And then I think I can fashion the conditions that would address the concerns that Mr. Hand and I share, and it sounds like his parents share, that would get Mr. Sherman some attention that he needs before these cases get resolved. And it might help resolve the cases if he can demonstrate he is in a course of treatment before the state decides what to do.
And Judge, if I can add, I just want to put this on record because I didn't get a chance to. There are 2 battery convictions that predate this one. So I just want to make sure the court's aware of that as you're coming up with the number.
Sure. No, I appreciate that. And that's the only way these could be felonies anyway, is that there has to have been some prior, not just battery, but a battery against a family member, or he'd still be down in state court. So, and I think that came up when we were working through, it would have been during the Miss Charles era. We spent a lot of time with Mr. Sherman when he was in the jury box and trying to convince us to not take him into custody. So, all right. So Ms. Wood, if you'll talk with Mr. Sherman's family and let me know financially how they might be able to structure something, we'll go from there.
And Judge, is it okay? I'm going to have Ms. Evans speak with them and then
Yep, we can do Mr. Crowe.
and we'll have them on their way if that's okay.
Excellent. That'd be great. Thank you, Ms. Evans. Okay. All right. So you two know I will be setting a bond. We just need to figure out financially what would work. The bond program through which I'll structure Mr. Sherman's bonds, most of what you put up, you get back. So it's not going to be through a bonding company. It's through what we call the sheriff's 10% program. So if I set a bond at $10,000, you have to post $1,000 plus a couple fees, but you get that $1,000 back, as opposed to a bonding company where it goes into their pocket, and nothing wrong with that, but it's just, you don't see any of that money back. Okay. All right. Thanks, Ms. Evans. Let's pivot then to Mr. Crowe and take his pleas. Mr. Crowe, you ready?
Yes, sir, I am, Your Honor.
You've been very patient.
Your Honor, maybe excuse for a moment.
Yes, sir. Yep. This will take 20 minutes, whatever. So if you'll be back within 10 or so, then we can switch to Mr. Barron.
Judge, if I may let you know, Mr. Crowe and I did not have a chance to fill out the plea sheet. I am confident, though, he will let us know if he needs me to step out and do a breakout session.
Yep. And I'll get that all on the record.
Thank you.
And Judge, are you okay if I stay seated just because he's on Zoom instead of moving to the?
I am okay.
Thank you, Judge.
Yep. And what I'll do is put Ms. Wood on the spotlight as well, so Mr. Crowe can see her more directly. Ms. Rivers, you ready? All right, we're getting on the record in case 22 SC 183223 and 22 SC 184895. Mr. Crowe, your lawyer, Ms. Wood, tells me that you are prepared to enter pleas in both those cases. Is that correct?
Yes, Your Honor.
Mr. Crowe, you have a right to be here in open court. You can waive that right and appear remotely, virtually like you are, but I need to make sure you're comfortable appearing from wherever it is you are.
Yes, sir.
Where are you?
I'm at home.
Okay, and what, is that in Atlanta? Is that in Rome? Where are you in Georgia?
It's in Dalton, Georgia.
Dalton, Georgia. Okay. Mr. Crowe, another important right you have is to have your lawyer right next to you during a conversation like the one we're going to have. But because you're in Dalton and the rest of us are here in Atlanta, Ms. Wood, your lawyer, is sitting in my courtroom. Do you waive your right to have Ms. Wood by your side during this plea?
Yes, Your Honor.
If at any point during our conversation you need to speak with Ms. Wood in private, let me know, and she can step outside the courtroom, give you a call, and you guys can speak privately. I don't think there's going to be anything we talk about that should surprise you to that degree, but that's not my call to make. So if you're hearing something that's not making sense, or all of a sudden someone is saying 50 years in prison and that's not what you were thinking was going to happen, then you should say you want to talk privately with Ms. Wood, and we will accommodate that. Okay?
Yes, Your Honor.
All right. In a moment, Mr. Hand, the prosecutor, is going to put you under oath. Once you're under oath, it's important that you answer all of his questions and mine truthfully and completely. Will you do that?
Yes, Your Honor.
All right, Mr. Hand, when you're ready.
Yes, Judge. Mr. Crowe, if you can for me, raise your right hand so that I can see it in the camera. Perfect. Please state your truth. Well, do you swear or affirm that any statements or testimony that you shall give the court today regarding the matter before the court shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can lower your hand. Please state your true, correct, and full name for the court.
Michael Lee Crowe.
Mr. Crowe, are you currently under the influence of any medicine, drugs, or alcohol?
No, sir.
Are there any medications that you would normally take today that you have not taken or been given?
No, sir.
How old are you, Mr. Crowe?
52.
And how far have you gone in school?
14 years.
Does that include some college?
Yes, sir.
Okay. And can you read, write, and understand the English language?
Yes, sir.
Do you understand that you have been charged in two separate indictments today? Those being the first 22 SC 183223, There are 3 charges under that indictment: theft by shoplifting, felony, willful obstruction of law enforcement officer by use of threat or violence, and the third being willful obstruction of law enforcement officer, a misdemeanor. The second indictment was actually an accusation, is 22 SC 184-895. And under that accusation is a single count of theft by shoplifting. Do you understand those to be your charges today?
Yes, sir.
And do you understand that you have a right to plead guilty or not guilty to the charges before you?
Yes, sir.
And do you understand that if you plead not guilty or remain silent and refuse to enter a plea at all, that the state is required to prove these charges against you at a jury trial?
Yes, sir.
Have you had an opportunity to review all of your rights with your attorney today?
Yes, sir, I have.
Have you had enough time to speak with your lawyer about the charges in both indictments, including all of the facts and circumstances regarding those charges?
Yes, sir.
Would you like more time to speak with your lawyer?
No, sir, we've discussed everything.
Are you satisfied with your lawyer's services?
100%.
At this time, Attorney Wood, would you waive formal reading of the indictment for purposes of today's plea?
So waived.
Would you also waive any and all defects in the indictment for purposes of today's plea?
So waived.
Judge, at this time, the state is unaware of any outstanding warrants related to both the accusation and the indictment.
All right.
Mr. Crowe, do you understand that the minimum and maximum sentence for each charge are as follows? For the first indictment, for the first case, it is theft by shoplifting, 1 to 10 years. Willful obstruction of a law enforcement officer by use of threats of violence, 1 to 5 years. And then willful obstruction of a law enforcement officer misdemeanor being 12 months.
Yes,
Thank you. And for the second case, the single count of theft by shoplifting, the minimum and maximum are 1 to 10 years imprisonment.
Yes, sir.
Okay. Do you understand that today you're entering a negotiated plea, which means that the state will recommend the following sentence to the court? In total, that is, and Judge, please stop me if you don't understand this first complicated line.
You're giving me right now the overall sentence?
Yes, Judge.
Or you're starting with 223?
The overall sentence.
Okay, I'll see what I can do.
Okay. And let me know if you want me to break it down too. The overall sentence, Judge, would be 10 years total to serve 5 years. Those 5 years reduced to time served upon the condition of entering and successful completion of the Carter Hope Residential Recovery Program.
Carter Hope Residential Recovery?
Yes, Judge.
Okay.
There are other conditions, but I want to make sure that makes sense.
Okay, it does. Is Mr. Crowe someone who has a 1-year mandatory minimum sentence that is non-probatable, waivable, anything like that because of the number of shopliftings?
No, Judge. I don't believe so. And when I say I don't believe so is I believe this case predates other shoplifting.
And I'll add some context. Or if you want me to add it now, I can do that.
Well, all I want to avoid, you all have previewed with me a little bit the direction Mr. Crowe is heading in, which is treatment, which is great. But we have bumped into before good arrangement, and folks ignore if you're on your 4th or subsequent shoplifting, whether it's a hamburger bun or a Mercedes that you shoplifted, is 1 year mandatory minimum to serve. And I can't reduce it. I can't waive it. I can't anything like that. And so what lawyers have done is said, you know what, we're actually making it theft by taking. So I just don't know Mr. Crowe's criminal history. And if what I learned from Ms. Jackson and others is that he's got 4 prior shopliftings, then this sentence will work, but he'll actually need to do a year in custody. It's like a recidivist, it's a baked in recidivist that you don't have to invoke. It happens automatically.
So
that's all.
If I may, Judge, this case is the last part of a puzzle. So he has recently pled in Whitfield, Coweta, Carroll, Douglas, Bartow, Gordon counties. His private attorney in Whitfield County actually has done most of the legwork on getting all of these taken care of. And my apologies, I should have confirmed with Mr. Crowe. I have been under the impression that he's been in custody for quite some time in other county jails so that it would.
9 months.
9 months. So you're close, but that's not 12 months.
Right. And so I would need to double check and see how much time he actually spent in Fulton. So if we could.
Okay. Well, I don't mind giving Mr. Crowe credit for Whitfield time or Bartow time. If it is more than 12 months, we don't run into that issue. And we may not run into the issue if he doesn't have these priors. And if all his pleas, to Mr. Hand's point, post date this I haven't looked at the indictment in 223. I noticed the conduct in 895 is 2 years old. It's from November of 2020. So that wouldn't trigger the recidivist provision. I hadn't looked up 223 yet because I
just took these pleas, Your Honor, within the past 60 days. I took the pleas on all the shopliftings, and prior to that, I didn't have any.
Okay, then we're all right.
And Judge, I believe it's only shopliftings, but there's one theft by taking in 96.
Okay.
And that's a while ago,
but it sounds like, well, let's cut to the chase on this one. Ms. Jackson, good morning.
Sorry, Your Honor. Good morning.
No problem. Does Mr. Crowe have any shoplifting convictions that you were able to discern from his GCIC from before 2022?
There are no theft by shoplifting convictions listed at that in 2022. I just see an outstanding hold in Noonan, Georgia for a theft by shoplifting, and the date on that warrant is March 4th, 2022. And he does appear to be on probation in Whitfield, Georgia, for felony theft by shoplifting. That disposition date was January the 11th, 2022, and the term is for 5 years.
Got it. Perfect. And Ms. Tucson, do you have anything different? Do you have convictions from before 2022 for theft by shoplifting?
Good morning. So with his, when Miss Wood, that's what I was inquiring about, because I see there's several on here at the moment that are all 2022. So from what I see on here, 1, 2, 3, 4, 5, 6, 7. So he's on probation for 7 cases at the moment.
Okay. But all those dates of conviction.
I guess she said. But the ones that are, there's one for a theft by taking in Bartow from 2016, Gordon County from 96, forgery and armed robbery in 2001, Cobb County.
Okay, great. Thank you. So we don't have an issue. I just didn't want us to get so far into this and then we crash into the immovable 1-year sentence.
Okay.
Thank you, Your Honor.
Thank you, Judge.
I didn't do anything, but you're welcome.
Make sure that we didn't have a flaw in it and not have to come back.
Okay. Well, there you go. Mr. Hand, keep going, please.
Yes, Judge.
While he's finding his place, you should understand, Mr. Crowe, if this treatment ends up not taking hold for you, your next shoplifting will be a mandatory year in prison, not in jail, not I can do 2 for 1. It will be 1 year down the road, Department of Corrections. Could be more than that, but no judge will be able to reduce it no matter what kind of program your lawyers line up for you. Okay?
Yes, sir. I understand, Your Honor, completely.
All right.
All right, Judge. Other conditions are 250 hours of community service, no drugs or alcohol, mandatory drug and alcohol evaluation and follow treatment recommended from that evaluation, to stay away from Home Depot at 6400 Peachtree Dunwoody Road in Sandy Springs, Georgia, which is in Fulton County, as well as a Walmart at 4735 State Route 138 in Union City.
Okay.
Mr. Crowe, did you hear all of those terms and did you understand them to be the negotiated plea?
Yes, sir, I do.
Okay. Do you understand that the court is not required to accept the state's recommended plea today?
Yes, sir, I do.
And do you understand that the court has the right to sentence you to the maximum sentence on each charge in each of the cases today?
Yes, sir, I do.
Do you understand that if there are multiple charges to which you are pleading guilty today, that the court also has the right to run those consecutive, which means one after the other?
Yes, sir, I do.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea that you were expecting today, that you have the right to withdraw your plea of guilty?
Yes, sir, I do.
Do you understand that if you are currently on probation or parole, that probation or parole may be revoked based on you entering a guilty plea today?
Yes, sir.
Do you understand that if you're placed on probation of any kind today, that you cannot violate any laws of any governmental unit? Those include any municipal, county, state, or federal laws.
Yes, sir, I do.
Do you understand that if you are on probation, you must follow all special conditions of that probation?
Yes, sir.
Do you understand that if you fail to follow all of the special conditions of that probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes, sir.
Do you understand that you are not allowed to possess or use a firearm while you're on probation?
Yes, sir.
Are you a United States citizen, Mr. Crowe?
Yes, sir.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm at all?
Yes, sir.
Do you understand that doing so will result in new criminal charges for which you will face a sentence between 1 and 10 years?
Yes, sir.
Do you understand that by entering a plea of guilty, you are waiving any and all defenses, including any mental health defenses?
Yes, sir.
Do you understand that by pleading guilty, you are giving up the following rights? Those include the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, as well as the right to appeal if convicted at a jury trial.
Yes, sir.
Is it your decision to waive these rights, which means to not use them, and enter a plea of guilty today?
Yes, sir.
Has anyone forced, threatened, or promised you anything for you to enter into a guilty plea today?
No, sir.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, sir.
How do you plead to the charges in indictment 22 SC 183223, theft by shoplifting felony, willful obstruction of law enforcement officer by use of threats of violence felony, and willful obstruction of law enforcement officer misdemeanor?
Yes, sir, I'm guilty.
And how do you plead to the accusation of 22 SC 184895, theft by shoplifting felony?
Guilty.
Are these guilty pleas freely and voluntarily given with the full knowledge of the charges against you?
Yes, sir.
Do you understand that you only have a limited right to appeal a guilty plea conviction?
Yes, sir.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a document that's called a habeas corpus petition?
Yes, sir.
Do you understand that for a felony, you only have 4 years from today to file a habeas corpus petition?
Yes, sir.
And do you understand that for a misdemeanor charge, you only have 12 months from today to file a habeas corpus petition?
Yes, sir.
Okay. Your Honor, at this time, the state will give a factual basis for the plea to both matters.
Ready.
All right. For the first matter, Judge, the state, if this went to trial, would be able to prove beyond a reasonable doubt.
This is the case ending in 223?
Yes, Judge, 223. On July 16th, about 11:43 a.m., a Sandy Springs officer, Mr. Giovanni, was dispatched to a Home Depot at 6400 Peachtree Dunwoody Road in Sandy Springs in reference to a shoplifting call. Once he arrived, he met with loss prevention, an officer who stated that he had detained a white male for shoplifting in the back of the Home Depot. Upon arrival, all of the loss prevention officers were on the lookout for Mr. Crowe because that same day at a different location, the Cumberland location, he had been identified as a suspect in a shoplifting crime. So they were on the lookout for him. Also, when he arrived, he was wearing the same clothing that he had on at the Cumberland Home Depot location. When he arrived, he loaded a shopping cart with several items. Those included items totaling $896.93 worth of Roundup refill, tools, rope, Milwaukee high output battery, a nail gun that was worth $349, and some drywall screw guns totaling $318 individually, collectively. With those items in the cart, Mr. Crowe proceeded to the checkout line where he scanned all of those items. When it came time to pay, he put his credit card in the machine, but took it out before the transaction completed to appear as if he had paid for the items. And then he left past all points of sale of the store. At that point, a loss prevention officer, Mr. Fleetwood, stopped him and detained him. All of the items were recovered because he didn't leave the premises, but he was taken to the back of the store, and that's when Sandy Springs police were called at that time. Once Sandy Springs police arrived, Your Honor, they began asking Mr. Crowe questions. He basically stated that he had just recently lost his son, his 21-year-old son, a year ago. He began sobbing, apologizing, stating that this was his life was in a tailspin since that death. The officer told him that he was under arrest. Mr. Crowe stood up after the officer asked him to turn around so he could put cuffs on him. At the point of putting cuffs on him, Mr. Crowe spun around the officer and ran through an emergency exit in the back of the store, right next to the loss prevention office. During that interaction, he hit the officer, bumped into him, and his body cam fell off. He didn't punch him. He just, during the interaction, bumped into him, and the body cam fell on the floor. He ran toward his car. He was tackled by loss prevention. He still did not stop. He ignored commands to stop. He ran to his car. Another officer with Sandy Springs police arrived with a taser drawn. At that point, he stopped and was apprehended and taken into custody. Those are the facts underlying the first case. For the second case, Indian 895, on November 28th, 2020, this is the 2-year-old case, a Union City police officer, Mr. Brown, responded to a shoplifting call at Walmart at 4735 Jonesboro Road in Union City. Upon arrival, he met with a loss prevention officer as well. Her name was Ms. Georgiana Bentley, who stated that she observed a white male wearing a plaid shirt and blue pants attempting to shoplift 2 computers. The man grabbed the computers and skipped past the scanning line and exited through exit doors at the Walmart. The loss prevention officer, Ms. Bentley, stated who she was, identified herself, and the subject took off running out the door toward his vehicle. Your Honor, based on the police report and the evidence I have, for some reason, Mr. Crowe returned to the store with those 2 laptops, and he was detained at that time. The laptops were recovered. They were valued at $892.17. And at that time, Union City Police were called. He was taken into custody.
So it sounds like no restitution from either case. Mr. Crowe was detained at the Home Depot, the item still in the cart, and he can tell us when we get to that point. But it sounds like he came back with the laptop, so nothing was lost.
I returned them, Your Honor. I went to the customer service desk and waited on the police.
Okay, great. And there'll be a chance, Mr. Crowe, if there are things you want to add, you've got a right to share whatever you do. Ms. Wood may cover that, but thank you for clearing that up.
And so that's the factual basis for the second case. Judge, normally with a history like this, the state would not consider probation, but considering the evidence that I've discussed with Ms. Wood regarding a drug habit fueling the theft here, as well as a possible life occurrence for him, considering his 21-year-old son was shot and killed preceding this event. Also, all of the items being recovered, no restitution being sought by Home Depot or Walmart. The state is comfortable with Mr. Crowe going into a residential program. The Carter Hope program is a 9-month program. And so, of course, the state would also look at the remaining 5 years of probation that are not a part of the conditional of him entering the program, and would look to revoke that if he were to reoffend as well. Also, other counties, including Whitfield and Douglas, have also done similar dispositions to ensure Mr. Crowe gets the help he needs.
Sure. No, I suspect there's a pretty meaningful incentive from some of those counties that Mr. Crowe sort things out.
Yes.
Okay, thank you. I feel like I've already received sufficient criminal history information from pretrial and from DCS. So I'm going to turn to you, Ms. Wood.
Thank you, Judge. Mr. Crowe is 52 years old. Like he said earlier, he lives in Dalton. He is a high school graduate. He has been gainfully employed in the past. He worked as a maintenance technician for Beaumont Products. I'm not sure if he's still there. He can tell us in a minute. And he's also done landscaping jobs in the past, Judge. As Mr. Hand has stated, all of this began after the loss of his son. Went into a downward spiral. He turned to shopliftings in the North Georgia counties to fund his drug addiction, Judge. The attorney, Todd Johnson, who, like I stated earlier, has done most of the legwork on this, instrumental in getting very similar sentences to what we're proposing in Whitfield, Coweta, Carroll, Douglas, Bartow, and Gordon. Having worked in Carroll County, I'm confident that, like you said, there is a major incentive for Mr. Crowe to do well with treatment and probation so that he avoids the consequences of a probation violation. Judge, we just ask that you accept the state's recommendation in this case. And if Mr. Crowe has anything to add, I'll turn it over to him.
I've got a question, Mr. Crowe, and then you can share what you want to share, if anything. And you don't have to say anything at all, but you are entitled to if you want to. What is the drug, or what are the drugs that you have struggled with the most since the loss of your son?
Cocaine and methamphetamine, sir.
Both equally, or one more than the other?
Equally.
Okay.
Your Honor, before all this happened, I was in the automotive industry for 6 years, or for 16 years. And the day that I was sitting at my desk and my son, I found out my son was, we lost him that morning. My life was turned upside down, Your Honor. I lost everything that I had, man. I lost everything. And, this is the first chance I've had to get to a program like this, and my family's standing behind me on it. And I've already paid for my entry fee in there and everything. And I just ask that you please accept the plea, Your Honor, and let me go get the help that I need.
Who, when you say your family stands behind you, who in your family is present in your life to help you navigate this?
My mother, my father, and my brother, and my sister.
Are they all in or near Dalton?
Yes, sir.
Okay.
Cartersville and North.
Got it. Well, I'm sorry for your family's loss. And I'm glad that you are going to hopefully avail yourself of this opportunity. It sounds like it is the last chance you've got before a number of these jurisdictions say what happened was tragic, but it doesn't justify you going on the spree you did. I lost track of all the counties you managed to get in trouble in. So this is an opportunity for you. You say you lost everything. I hope you find soon hope, because that's what you're going to need to get you through the program. I'm not familiar with the Carter Hope Residential Recovery Program, but I'm active in our accountability courts here in Fulton. And I have seen the turnaround that people are able to make when they're committed to it. But if it's just a way to avoid some jail, and that's the only way they've invested in it, it ends pretty quickly, because they're not motivated to take the steps they need to maintain their sobriety. But it sounds like you may be heading in that direction, which is good.
Thank you, Your Honor.
Mr. Crowe, I find there's a factual basis for your plea. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea. You're doing it of your own free will. Is that correct?
Yes, sir.
And knowing means you've understood all the things we've talked about. Do you have any questions about anything anyone has said?
No, sir.
All right, then I will accept your plea in both cases. I'm sentencing you pursuant to the Probation Options Management Act. And all that means, Mr. Crowe, is that while you're on probation, which you will be for a few years, if you have what we call a technical violation, something minor, you and probation will sort that out. But if it violates one of the special conditions, and I'll tell you what those are in a minute, or you get arrested for a new felony, a new crime, then I could revoke up to the entire balance of your probation, and that will come back to me, not to just the folks at probation.
Sure.
I am going to sentence you in the case ending in 223. I'll find that case again on count 1 to a term of 10 years to serve 4 years. Those 4 years will be reduced to the time you've already served, and the remaining 6 will be on probation. Count 2 will be 4 years to serve. Count 3 will be 12 months to serve. Those will all run concurrently with count 1. It will be a special condition of your probation. Remember, special means it's an actual legal term. It means if you violate that condition, it's not just a technical violation, but your entire probation could be revoked. Special condition number 1 is that you enter into and complete at least 9 months at the Carter Hope Residential Recovery Program. Special condition number 2 is that you complete over the course of the 6 years of probation, 250 hours of community service. Mr. Crowe, do you have any reason, personal or professional, that you'd need to be back in Fulton County?
No, sir.
Then it will also be a
only thing I have to do is come back. I had a charge that they dropped there and I have to come back to Fulton County to pick up a bond there.
Okay. Well, it's going to be a special condition of your probation that you stay out of Fulton County, but for legal matters. So don't come down here to shop. Don't come to any Home Depot. Don't come to any Walmart. You don't need to be in Fulton County while you are under this sentence. Okay.
Sure.
In your other case, ending in 895, that has just the 1 count of shoplifting, I will sentence you to 10 years to serve 4. Reduced to time served with the balance on probation. Special condition there, only 1, and that is that you enter into and complete at least 9 months of the Carter Hope Residential Recovery Program. And that sentence will run concurrently with your sentence in the case ending in 223. Any questions about that sentence, Mr. Crowe?
The part about coming to Fulton County is that am I banished from Fulton County during the probation? Is that what that means?
That's what it means. Now you can pass through it if you're on I-75 and you're heading south to Clayton County. It's fine to be driving through it, but if you get pulled over on Peachtree or you are shopping in the Walmart that was the subject of the second case, that would be a violation of your probation and could be a basis to revoke your probation.
Okay, thank you, Your Honor.
Now, one caveat to all that, if you end up getting a job after you're done with the treatment center and that job requires you to work in Fulton County, you should reach out to Ms. Woods, and I may be willing to modify that condition, because if the one job you can find or the best job you can find requires you to do work in Fulton, I don't want to keep you from doing that. But if you're working in Walton County, you don't need to be in Fulton County.
Thank you for that part right there, Your Honor.
You're welcome. Mr. Hand, anything else in Mr. Crowe's cases?
Judge, I may have missed it, but did we say, did you order no drugs or no alcohol?
So I didn't. You also had recommended that Mr. Crowe submit to a drug and alcohol evaluation and treatment if necessary, but he's getting treatment. It is a special condition of his probation that he spend 9 months residentially living at the Carter program. So it's just belt and suspenders. He'll get more than enough treatment then, and he'll need to participate in whatever aftercare there is.
Understood, Judge.
Okay. All right. Ms. Wood, anything else?
No, Your Honor.
All right. So there's no specific stay away from either of these places. You're staying out of Fulton County, which has within it the Walmart and the Home Depot that we were dealing with. You're going to need to chat with Ms. Tucson, the probation officer, but I'm going to move you in a breakout room to have that conversation. She just needs to get your address and figure out where you're going to report to probation. Okay.
Yes, sir. Yes,
when
sir.
you're done talking with her, you are free to drop off the call.
Thank you, Your Honor.
All right. All right, so click on the little invitation on your phone, and that should get you in the breakout room. Good, there you go. All right, Mr. Zeff, it's 11:20. We have another plea we could do. And yes, we'll do the other plea. Excellent, let's do that. Didn't matter what you were gonna say, you got overruled by the back bench. So, as you were, Mr. Zeff. All right, let us pivot to Mr. Barron. You still with us, Mr. Barron?
Yes, Your Honor.
Excellent. Let me get you on the screen. Ms. Rivers, are you ready? All right. This is case 22 SC 181654, State versus James Barron. Mr. Whitenauer will be representing the state. Ms. Wood, this is your client. Mr. Barron, you just sat through one plea, so I think you know what the routine is. You're going to be put under oath in just a moment. But I need you to tell me on the record that you are waiving your right to be here in court and you're comfortable proceeding from that wood paneled basement you're in.
Yes, Your Honor.
Okay, you also have the right to have Ms. Wood by your side, but she's here. Will you let me know if you need to speak with her in private?
Absolutely, Your Honor.
Okay, then let's move forward. Mr. Whitenauer.
Thank you, Judge. Sir, my name is John Whitenauer. I'm an assistant district attorney with the Fulton County DA's office. I'm going to be asking you some questions. If you'd please respond yes, no, or as appropriate so that the court reporter can take down everything that we say. Agreed?
Yes, sir.
If you would please raise your right hand. Do you swear or affirm the testimony you're about to give in the matter pending before this court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Please lower your right hand. Please state and spell your true, correct, and legal name.
James Theodore Barron, James, Theodore, Barron.
Please state your date of birth and your age.
August 20th of 1990, and I'm 32.
Are you now under the influence of any medicine, drugs, or alcohol?
Just antidepressants.
Does that affect your ability to understand the nature of the proceedings here today?
No, sir.
How far did you go in school?
A year of college.
Can you read and write in the English language?
Yes, sir.
Have you had an opportunity to review the document that charges you in this case, that is the indictment?
Yes, sir.
Do you fully understand the nature of the charge pending against you?
Yes, sir.
By pleading guilty today, you were giving up certain rights. You were giving up the right to a trial by jury. Do you understand?
Yes, sir.
The right to be presumed innocent. Do you understand?
Yes, sir.
The right to confront any witnesses who may testify against you.
Yes, sir.
The right to subpoena any witnesses for your defense.
Yes, sir.
The right to testify yourself and to offer any other evidence in your defense.
Yes, sir.
The right to have an attorney assist you throughout the trial proceedings.
Yes, sir.
And the right to not incriminate yourself.
Yes, sir.
You understand that you are waiving or giving up all of those rights by entering a plea today.
Yes, sir.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by a jury?
Yes, sir.
Do you understand that you're entering a plea today to one count of use or installation of device to film underneath or through an individual's clothing, and that carries a sentencing range of 1 to 5 years in confinement?
Yes, sir.
Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No, sir.
Do you understand that this is a negotiated plea?
Yes, sir.
And do you understand that the state will be recommending to the court a sentence of 5 years on probation?
Yes, sir.
And Your Honor, I would note that this negotiation was made between ADA Charles and defense. In looking at the statute, it does state that the sentence must be 1 to 5 years. And so to be technically accurate, I think, Your Honor, if you accept the plea, it would need to be 5 serve 1 and suspend.
Okay, I'll take a look. This is a statute I've never worked with before. You
Yes,
don't
Judge.
get a lot of the device filming under the clothes of another. So I had to look up the range as well. But I will look at that further.
Yes, Judge. Sir, Do you understand that the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which again is 5 years in confinement?
Yes, sir.
And Your Honor, will you be allowing him to withdraw his plea today?
Yes.
All right. And do you understand that if the court does not accept this negotiation, that the court will allow you to withdraw your guilty plea today?
Yes, sir.
So you need to understand that should the court sentence include a period of probation, you'll be required to obey both general conditions of probation and special conditions of probation. You'll be required to follow the general conditions of probation that probation will give to you when you meet with them, including but not limited to that you are not to violate the criminal laws of any governmental unit. You will also be required to follow certain special conditions, which in this case would be that you continue with Sex Addicts Anonymous therapy on Tuesdays and Thursdays, facilitated by Al Elmore, that's A-L, Elmore, E-L-M-O-R-E. Counseling, that you complete 150 hours of community service, that you stay away from the incident location, Walmart, located at 5200 Windward Parkway in Milton, Georgia, and that you have no contact with the victim, in this case, Amy, A-M-I, Tuckley, T-U-C-K-L-E-Y. Do you understand?
Yes, sir.
Do you understand that a violation of any of these conditions, general or special, could lead to a revocation of your probation?
Yes, sir.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, sir.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, sir.
Are you satisfied with what your attorney has done for you in this case?
Yes, sir. Absolutely.
Do you have any more questions for your attorney before we go on?
No, sir.
Have you understood everything I have asked you so far?
Yes, sir.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes, sir.
And how do you plead to the one count?
Guilty.
Is your decision to plead guilty made freely and voluntarily?
Yes, sir.
Are you a United States citizen?
Yes, sir.
Sir, if you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file a direct appeal. The second way is a habeas corpus petition, and for this one felony count, you have 4 years from today to file a habeas corpus petition. Do you understand those time limits?
Yes, sir.
All right. Your Honor, if this case were to proceed to trial, the state would prove beyond a reasonable doubt that on or about May 21st, 2018, Officer Stannis, that's S-T-A-N-I-S-E, with the Milton Police Department, went to 125 Watermill Falls in Alpharetta to speak with the victim, in this case, Miss Amy Tuckley, regarding an incident that she had posted about on a Nextdoor app. She advised that earlier that day, she had gone to the Walmart located at 5200 Windward Parkway in Milton, Georgia, which is located in Fulton County, when she noticed a man was following her in the store. She stated that while she was in the shoe aisle, she heard 2 clicks. As she turned around, she saw a man, later identified as the defendant, James Barron, crouched behind her, holding a phone in his hand. She believed that the man had used his phone to take a picture of her under her skirt. When she turned around, the man immediately walked away. She then followed the man and took a picture of him with her phone. She was able to provide a description of the man and that picture that she took of him to law enforcement. Ms. Tuckley had actually reported that earlier at the Walmart when it occurred to a Milton Police Department officer, but that officer did not make a report. So it was only after she had posted about this that Milton PD began a formal investigation.
It was Milton PD monitoring Nextdoor that prompted the investigation.
Well, I have an answer to that, Judge. Actually, Channel 2 Action News saw the post on Nextdoor and then contacted Milton PD.
I would not want to be that officer who didn't make a report.
And I do not have that officer's name for you.
He probably is okay with that.
Yes. Judge, Officer Stannis then went to the Walmart and met with the loss protection associate there. That's Nicholas Colban, in. He advised that he had followed the defendant around the store earlier that day due to his suspicious activity, and Colbon was able to provide Officer Stannis with store surveillance footage. It does not capture the defendant taking a picture under Miss Tuckley's skirt, but does show her then following him, pulling out her phone and taking his picture, and he thereafter quickly exited the store, leaving in a white F-150. This case was ultimately assigned to Detective C.A. Bradshaw, who, after reviewing the initial report, created a BOLO for the defendant. A Lieutenant Shane Bowman with the East LJ Police Department responded to that BOLO. He recognized the defendant from an arrest in April of 2018 for the same charge with the incident location of Walmart in LJ. That case was ultimately null pros, Judge. Lieutenant Bowman also advised Detective Bradshaw that the accused had also been arrested in 2016 for the same charge at an Ingles grocery store. No charges were brought in that case. Your Honor, because of that null pros and no charges in the 2018 and 2016 cases respectively, this defendant does not have any felony convictions, and I understand that defense will be asking that he be sentenced as a first offender, but given this history of 2016 and twice in 2018, the state does not view this as errant behavior and views it as a pattern of behavior in invading the privacy of residents in our county as they shop in these stores. So we would ask that you deny that request. Your Honor, we have spoken with the victim in this case several times. And when we spoke out with her, she stated that she was creeped out by his actions, that she was appalled that he would be so brazen. And her immediate reaction was to find him, get his picture, and put his face out there so that this would not happen to anyone else. Despite those strong feelings, she says she has no objections to the proposed resolution of probation and was glad to hear that he has been getting treatment. And I would note that defense has provided to us records from that counseling program, a log and a letter from the therapist showing that he has been in continuous therapy since June of 2018. So, Your Honor, with that, we would ask that you accept the recommendation of 5 years to serve one suspended, balance on probation with the special conditions previously mentioned. Nothing further from the state.
I have a question. So LJ Police assists Milton Police in figuring out what exactly is going on. Was anything ever ultimately seized from Mr. Barron that confirmed pictures were taken? Because I don't think the indictment is attempted, it is actual.
Mm-hmm. Yes, Judge. So I neglected to include the fact that officers did, in fact, speak with the defendant once he had been identified. He admitted that he'd been at the Walmart, admitted that he had his phone, denied taking any pictures, but when he was asked for his phone, he replied that it was, quote, broken.
Okay. Thank you. Ms. Jackson, good morning again. Do you have any criminal history information for Mr. Barron?
Is Mr. Barron on the calendar, Your Honor?
Oh, you know what? There's a separate calendar that we did. He's on a trial calendar, but his lawyer, Ms. Wood and Ms. Charles had sorted this out, and we thought we would do it today. So he was not on your radar. I think it might have been emailed out, but it was emailed real recently. What kind of information do you need to look him up?
First, let me get his full name, please.
It's James, middle name is Theodore, and last name is Barron, and that's with 2 R's.
Is there a date of birth?
He can tell us.
August 20th of 1990.
1990?
Correct.
And Your Honor, do we have a case number or a booking number so I can check and see if he's in our system?
Sure, I've got an indictment number, 22 SC 181654.
Okay, if I can have just a moment, please.
Sure. No, we'll do a couple other things. Ms. Tucson, do you have any information on Mr. Barron?
I did retrieve his identifiers, and there's no record found for probation for felony.
Okay, thank you. Ms. Wood, why don't you get started and then we'll hear from Ms. Jackson as we wrap up.
Thank you, Judge. I also took another glance at the statute. My read of it is that it's imprisonment of not less than 1 year or no more than 5, a fine, or both, or in the discretion of the court as for a misdemeanor. So I just wanted to let the court know of that. He's 32 years old, Judge. He lives in Ellijay, Georgia. He's been in Georgia the past 10 years. He went to trade school after high school to be a mechanic. Currently, he is working as a carpenter. He has his own business in Ellijay. Judge, this is a 2018 incident. He's had no other incidents of this nature since then. As Mr. Whitenauer stated, I did share the attendance records that show he has consistently been to therapy and to all of his scheduled appointments for treatment since 2018. And he plans clearly, because it's a part of his probation conditions, but he has no issue continuing on with his therapist and any other counseling. The only thing that I did want to tweak is that I know we're doing it specially that he continue with the Al Elmore counseling. If we could just add an addendum, because things happen, if we could put in there or some
equivalent.
Yes.
So Al Elmore is different from Sex Addicts Anonymous? Correct. Or is that the same thing?
No, Al Elmore is my therapist, and I reached out to him immediately after I was charged, and then he recommended that I go to Sex Addicts Anonymous, and he worked through a workbook with me, and then I've been seeing him. I saw him weekly for 2 years, and it's been every other week since then.
Okay. All right. Yes.
So I just wanted to make that clear, Judge. Thank you. And then the only other thing is, again, I am asking for first offender treatment. I think in my conversations with Mr. Barron, he has demonstrated a commitment to keep his life on the right track and to stay out of trouble. And again, he's 32 years old. He doesn't have a record. So I think he is the perfect candidate for first offender treatment. And last but not least, I am asking for a behavioral incentive date for this case. Otherwise, we would ask that you accept the state's recommendation.
I have not done a behavioral incentive date in a while. Do I simply say there ought to be one? I know it has to be at least X years out, 2 years out. Or if I say there ought to be one, then probation calculates it.
So I want to double check with Ms. Tucson because I've heard conflicting answers on this.
Then we'll wait. I'll flag that when I'm pronouncing the sentence.
Thank you, Judge.
Okay. All right. So Ms. Jackson, did we give you enough time or should I start doing some talking on my own?
Please start doing some talking on your own, Your Honor.
Okay. Keep doing what you're doing. Mr. Barron, you mentioned that you take antidepressants. How frequently do you take those?
Daily, just once in the morning.
Did you take one this morning?
Yes, sir.
Okay. And that you've already answered when Mr. Whitenauer asked, but that does not in any way impair your ability to understand what we're talking about?
No, the exact opposite, actually.
Helps you focus. Good. Mr. Whitenauer, is this offense, using a device to observe underneath clothing, one that would require Mr. Barron to register as a sex offender?
No, Judge.
I didn't think so. All right, Mr. Barron, first offender is primarily an opportunity for someone who is a first offender, meaning he or she doesn't already have a felony conviction. And while I appreciate Mr. Whitenauer's observation that you came pretty darn close to already having one because you allegedly engaged in some of this same, I'm going to use this word several times, and I get it from Ms. Tuckley, creepy activity, you don't have any convictions yet. If I sentence you as a first offender, this will not be a conviction. It will be as if you're under sentence. All these conditions of probation that we're going to talk about, you'll need to abide by. But if you are ever asked because you're seeking employment or trying to go back to school, are you a convicted felon? The answer would be no, because you are what we call a first offender probationer. If you successfully complete your sentence, you can get this removed from your record because it won't be a conviction. That's the benefit of first offender. The downside of first offender is that if you should violate your probation, I can not only revoke your probation, but I could resentence you without a trial. All I'd have to do is find that you violated your probation, which is a pretty low standard of proof, and then resentence you as a felon up to the maximum in this case, which is up to 5 years. So if you have any concern that you are at risk of reoffending, you don't want to be a first offender. But if you think you have this situation under control and you otherwise will be staying out of law enforcement's way, then first offender is an opportunity for you to keep your record clean as you try to build your life in whatever direction you're going. Do you feel like you understand the risks and the benefits of first offender?
Yes, sir.
Do you want to be sentenced as a first offender?
Yes, sir.
Okay. Mr. Barron, I find there is a factual basis for your plea, and that your plea is knowing and voluntary. Knowing means you've understood all the things we've talked about. Anything you have a question about?
No, sir.
Voluntary means no one's forcing you to do this, but that you, after consulting with your lawyer and anyone else you'd want to talk to about this, have decided that it's in your best interest to move forward with a plea. Is that correct?
Yes, Your Honor.
Then I'll accept your plea. I'm sentencing you pursuant to the Probation Options Management Act, which means only that while you're on probation, if you have a technical violation, you and probation will work that out. But if it's more serious, you and I will work it out. I will sentence you, and I've looked at the statute as well. I believe I can impose a sentence of simply 5 years probation, and I will do that. It will be a special condition of your probation that you continue regular treatment with Al Elmore or any substitute counselor if you and Mr. Elmore decide you need to part ways, or you move somewhere else in Georgia, or Mr. Elmore retires. You will need to maintain that counseling at whatever frequency your counselor or therapist determines you need. Sounds like right now it's every other week. If Mr. Elmore ends up saying once a month, that's great. And ultimately, if Mr. Elmore says, I don't think you need it anymore, then if he provides a letter to that effect, probation won't require you to be getting that therapy. You will also need to continue to attend sessions at Sex Addicts Anonymous. How frequently are you going now?
Every Tuesday and Thursday, and unless I have issues. Lately, my attendance has been lacking because my girlfriend's mother just passed in August, so it's been a little rough, but excuse me. But other than that, every Tuesday and Thursday, and I try to make sure it's mainly Zoom, but I go in person when I can because it's down in Marietta.
Well, I'm going to require at least 5 sessions of Sex Addicts Anonymous a month. You can do more, and that may be better for you, but you need to do at least 5, regardless of what's going on in your life. You'll also need to complete 150 hours of community service and stay away from the Walmart on Windward Parkway. And finally, no contact with Ms. Tuckley, who I assume is a stranger to you, other than she caught your eye in that store. But we can find people online these days. Don't do that. If she presents any evidence that you reached out to her, even if it's to say, I'm sorry that I was creepy, that's creepy to reach out to her, and that'll be a violation of your probation. Okay?
Yes, Your Honor.
Ms. Jackson.
All right, I see 4 cycles out of Georgia. The last arrest was October the 18th, 2021 in Gilmore County for simple battery, family violence. There was no disposition for that. Prior to that, he was arrested May the 25th, 2018 in Milton, Georgia, for knowingly using / installing a device to observe.
All right, that's our case. All right.
Okay. Prior to that, he was arrested in LJ. That was on April the 20th, 2018. It was pretty much for the same charges, knowingly using / installing a device to observe. There was no disposition for that arrest. Prior to that, he was arrested July the 20th, 2016 in East LJ for peeping Tom, disorderly conduct. The disorderly conduct was null prost on May the 1st, 2018. Doesn't say anything about the peeping Tom. He does have a history out of North Carolina and South Carolina, if you would like to hear that.
Any convictions or just
I'm not
arrests?
sure, Your Honor. I'm just pulling it up.
He has a conviction out of South Carolina for shoplifting in 2008.
It's just
Misdemeanor?
one. I'm sorry, counsel, go ahead. I apologize.
No, I apologize. I interrupted. I was just telling the court that he does have a misdemeanor conviction for shoplifting out of South Carolina, 2008.
Okay. Just want to make sure there are no felonies. If there's a felony, Mr. Barron cannot be a first offender. I don't want to misuse that for him. I'll tell you, Mr. Barron, you're right on the cusp of first offender making sense. I'm going to give you the benefit of the doubt because this was 4 years ago. And the only thing that's happened since then is it sounds like there was a family violence battery arrest in another county, which is different from peeping Tom and using a device to observe underneath clothing. But I hope for you that the treatment you're getting from Mr. Elmore and the sessions you're going to are keeping you in a safer lane than you were in earlier. And thank you, Ms. Jackson, for that information.
Judge, I do have information about the behavioral incentive date.
Yes.
Like. Your Honor, under OCGA 17-10-1, subsection A1B1, when a defendant with no prior felony conviction is convicted of felony offenses and the court imposes a sentence of probation, the court shall include a behavioral incentive date in its sentencing order that does not exceed 3 years from the date such sentence is imposed. Then goes on to talk about probation and what it must do. But we would be asking that, consistent with that statute, that you assign a behavioral incentive date and that it be 3 years.
Sure. And I will, but I will make it 3 years. I think it can be shorter than that. That's why it says at most. But given all the things I've been hearing about Mr. Barron and my tentativeness with the first offender piece, I'll keep that behavioral incentive date at 3 years. So it'll be November 4th, 2025 will be your behavioral incentive date, Mr. Barron. And what that means is if you get to November 4th, 2025, there have been no issues, you've been going to treatment, you've completed your community service, you can talk with probation about having your case closed out. They are in the business of making sure folks do what they're supposed to do. And if you've been doing that for 3 years, maybe they should move on to folks who are struggling a little bit more than you'll be struggling if you've done that. So that is the plan. Any questions about your sentence, Mr. Barron?
No, Your Honor.
Ms. Wood, anything else on behalf of Mr. Barron?
No, Your Honor.
Mr. Whitenauer, anything else?
Nothing from the state.
All right, Mr. Barron, I'm going to move you and Ms. Tucson into a breakout room. She's going to need to get some address information from you and give you some reporting instructions. When you're done speaking with her, you are free to drop off the call.
Thank you, Your Honor.
All right.
Okay.
See if I can make this work. Mr. Barron, you may need to press a button to get into that breakout room. There you go. Excellent. Ms. Jackson, you are free to go. Thank you for working with us this morning.
Thank you so much, Your Honor.
Ladies and gentlemen, we are done with the pleas that we were taking this morning. And I think we've got a little time. Mr. Zeff can be our time monitor to talk with you about what you've seen, about what goes on in Fulton County Courthouse. I think you heard from Judge Ingram very, very briefly this morning at the State Bar a little bit about Superior Court. You're in a Superior Court courtroom where we handle felonies on the criminal side. So anything punishable by a year or more. So it would be theft by shoplifting would be one of our least serious of matters, all the way to something where you could get the death penalty. And I've asked the prosecutors as well as our public defenders to stay, because you may not be interested in what I have to say. You may want to ask the practitioners what they have to say. I want to give you a little context. The pleas we took were a little different today. One, because they were virtual. We still do a lot virtually, usually not pleas, much more procedural things rather than resolving a case. But because neither of these gentlemen was going into custody, they'll be reporting to probation. This makes sense. And frankly, it is helping improve access to justice. Mr. Crowe was 100 miles away. I mean, it made sense for him to do that. And actually, LJ is not so close either. But that is very atypical. 99% of our defendants are very local, and they're either here in person or they're coming through that wooden door there with no windows on it because they're in custody. Secondly, this was a little atypical because most defendants in Fulton County are Black, and those two gentlemen were white. But most of what we're working with are young Black males in terms of our defendant population. These charges were a little less serious. One of them I never had before. That whole peering up the skirt thing is very uncommon. Shoplifting is not so uncommon because we have a lot of cases that are fueled. The criminal activity is fueled by mental health issues and or addiction issues. They usually co-occur. And a lot of the property crime, someone breaking into your car to take your iPad, they don't want your iPad. They want the $10 they're going to get for that iPad when they fence it because they can buy their next fix. And so a lot of the property crimes we get, burglary, entering auto, theft by shoplifting, they're actually drug crimes. But when the person's arrested, he or she may have drugs in the system, not drugs on them. We see a lot of that. Unfortunately, lots of crimes of violence, but that typically doesn't happen virtually. Those are the folks who are coming in through that door because they're in a no bond status. They were arrested with the gun still on them. There's a dead body on the pavement, something like that. And as you read in the media, there's a lot of that going on. And so we have lots of those cases. Those tend not to result in pleas. Those tend to be trials. And so you'd be observing it as a juror, or you'd be in the gallery watching because you are somehow connected to someone involved with the trial. Otherwise, this is how we do things. This is the standard plea colloquy. These are actual lawyers. We didn't bring in actors. And the whole exchange we had was as thorough or not thorough, depending on your perspective, as we have when someone enters a guilty plea. And the range of support that you heard about, or lack of support, drug treatment, counseling, that's fairly typical. The one difference, Mr. Crowe had found his own program. Usually the public defender's office that has a good army of social workers, they're finding the program, or they go through a court program. Judge Ingram was supposed to, because I asked her to, tell you briefly about accountability courts, but she said she only had 7 minutes and it went by real quickly. But accountability courts are a big part of the work we do with folks like Mr. Crowe, except imagine it being someone local and usually someone who's Black as opposed to white. And I flagged the race only because the demographics are different. Those were North Georgia people, and this isn't North Georgia. But our accountability courts are very, very busy, and they do great work. They get folks out of this cycle of arrest. You dry out a little bit, you're released, you relapse, you're arrested again, and it's a cycle again and again and again. And the accountability courts get folks treatment, but hold them accountable if they don't do well. And we enjoy some good successes there. That's all I wanted to. Oh, last thing. These cases were a little older than what we typically see. 2018, the conduct for Mr. Barron. Cases that run through the specialized unit sometimes move a little more slowly because they filter them more. What you would tend to see is a lag of about, if a case is working out, 9 months to a year from the alleged incident to the resolution of the case. This was, Mr. Barron's was, that whole 4-year thing is much less common. Mr. Crowe, he did have one thing from 2020, but he had so many moving parts. He just was, I mean, he was what we call riding the circuit. He was going to each of these counties where he had picked up a case. And fortunately for him, he had the gentleman whose name I don't remember who had lined up a coordinated disposition. Because some folks, if they don't get their lawyers talking to each other, get 6 months here, 6 months, and all of a sudden they've done 5 years. What they needed was drug treatment. And when they finally get released, they say, oh, you did 5 years, I'm gonna just let you out. But they didn't get any treatment, and guess where they are back in 3 months. So anyway, we can field any questions you want about those cases, other things you've seen. How much time do we have?
We have
we all work for Pat, and so she said at noon we need to.
Okay, so we'll give more succinct answers. Yes, ma'am.
First of all, thank you all for having us. It's really interesting. I know, Your Honor, you've been part of Leadership Atlanta, so you probably remember from race day.
I'm a survivor.
We talked through all the differences, and one thing, I can't remember the exact stat, but sentences for white males versus black males are different. And I'm just curious, do you have any reporting or anything like that that helps manage potential bias there, both for you and then for defenders?
Sure. So I understand that that's what data show sort of writ large. I don't think that's so accurate in Fulton County for a couple reasons, not because we are so enlightened and we've conquered our implicit biases, but largely because of the population base. 90-ish% of the defendants are Black. And so you don't have a 50-50. So you could say, well, look, why is it that all the white defendants are getting a different sentence than the Black defendant? You have so few white offenders that drawing comparisons is, from a data perspective, a little suspect. And so I think the metrics would be more, are sentences different across judges? Answer will be yes. Judges have their own biases, and one judge might say a burglary, you've invaded a woman's castle, and so you need to serve time, whereas another judge might say, I think getting you some treatment would result in a different outcome. But I haven't experienced either from the prosecutors recommendations that strangely seem lower because of someone's race. What I do see as a difference, and there's a clear correspondence here, is socioeconomics make a difference. Because someone who can afford a private attorney can probably afford to line up a treatment program that's super fancy, and the providers come to court. And frankly, I've had PowerPoints where a defense attorney says, here's the provider, and this person's already enrolled and they've been doing this for a while. And those resources don't exist for the public defender's office. And they certainly don't exist for the indigent defendants. They are trying to scrap together, what am I doing the next day? And that can result in disparate outcomes. And insofar as that's driven by race, because socioeconomics are affected by endemic racism, 100% I agree. I don't think we have an issue in Fulton County, though, of, oh, I associate more with this guy, he's from my neighborhood, and your sentence is going to be different. But I'd ask our public defender to speak to that, because she's on the receiving end of sentences much more so. And Ms. Wood has been doing this a little longer than Mr. Hand. So she's just going to have a richer data set. And she doesn't need to agree with me. It's okay if she disagrees.
No, he actually laid it out very well. He's correct. Most of my clients are young Black men. But he's absolutely correct. I don't see any difference in my offers from the state. They're all pretty much the same. It doesn't really matter who is my client.
And keep in mind, I'm sorry to speak over you. The public defender, her boss, Black guy, the DA, Black. I mean, this is not, Fulton County is a situation where leadership, our bench is very racially balanced as well. In fact, white males are in the minority on the Fulton County bench. I'm not bringing a lawsuit, but I'm in the minority. So we institutionally, the institutions are run by people of color, which is great. I don't have an issue with that, but I think that is one way to inoculate some against some of the concerns that exist in America. This is not a sanctuary here, but it's a way to show how you might get different outcomes because of how things are structured differently. And so in Fulton County, we now have a brand new chief of police, white but Black sheriff. I mean, you can rattle off mayor, et cetera, but that has a salutary effect. Because I think the prosecutors come at this as saying, let's look at the offense. What did he allegedly do? He raped someone, he shot someone. That's serious, as opposed to, Georgia Tech grad, we need to do something different with this person. You bet. Yes, sir.
A quick question for you. Earlier, Judge England told us in 2021, there were 13,600 filed cases. I'm curious, how many public defenders exist out here?
Not enough.
That's good. Yeah, good question. So my office, we handle the felonies in Fulton County, and then we also have a state court division that does all the misdemeanors, and we also have a juvenile unit, and then you have the city of Atlanta has its own public defender office. gosh, I think we have 2 public defenders for each courtroom.
You got 30, there are 15 courts that handle criminal, so there are 30 there. You've got all sorts in non-complex and first appearance. You have appellate public defenders.
Right. So I think, I don't even know what our current numbers are because we had like a bit of a hiring situation, but I think we're almost full. But he's right. There's 30 that handle the felony trial division. And then I think we also have 30 in the pre-indictment unit. And then I'm not sure what our numbers are for the juvenile division. And then we have a lot of state court attorneys. So we probably have about 100, I think.
We're blessed. There's a lot of funding there. They recently got a big raise, well-deserved. I don't know that we're quite at parity where district attorneys are paid the same as public defenders. But most importantly of all, they're great lawyers. You will read about it where someone has to, because of pro bono requirements, is the public defender for someone on death row and he's a drunk and he hates defendants anyway. That is not Fulton County. We have folks who are very zealous in a good way on behalf of their clients. And so we don't suffer from underrepresentation of indigent clients, which is good because most of our defendants are indigent. But I also don't get the sense, I very rarely hear from the public defenders, we can't go forward today because we just haven't had enough time. Let's do one more question. Pat can come in here and, yeah.
So again, thank you. I had a question about the first offender. So I was surprised, and it was very helpful to hear the explanation when you guys started rattling off all of the circumstances that the young guy had last. But what's the success of first offenders? Like, does it work? I've read about it a lot, but I just love a point of view. I know you don't have data in front of you, but does it work?
It is a big success for someone who you would say, of course, first offender makes sense. I'll just make up a scenario, but we get this. 35-year-old guy who had too much to drink one night and got rough with his significant other, his intimate partner, and it's a felony and has no past, nothing like that before. And maybe this person is plugging into treatment, a professional, et cetera. That person, unless there's a mental health issue, isn't going to reoffend because he or she saw, I could lose my job, I could lose this and that. Where it doesn't work, but we hear people clamoring for it, is a 17-year-old kid who has a juvenile history, none of which counts for purposes of first offender, but has been unfortunately out in the streets for a long time. And his first felony, and hey, could he get first offender? It was armed robbery, reduced to robbery, and how about 5 years probation? As long as he doesn't get in trouble during those 5 years, doesn't first offender make sense? Conceptually, it does. But unfortunately, I'm going to not be right with the numbers, but 60%, 70% of those young men, within a year, they're back in court, and that first offender was a waste of everyone's time. So I'm more reluctant to do it when there is not a past that I can look at. I understand with Mr. Barron, some of his past was, wait a minute, you were doing some creepy stuff. But the treatment that he was plugged into and the fact that they're 4 years old and there hadn't been another one, it works much better for someone where you see structure around them, whether it's family or I'm a college student and I messed up, I got caught with more marijuana than is just a misdemeanor. You want to give those folks a second chance. You want to give everyone a second chance. Just the success rate diminishes greatly when you look around and there is the support network for that young man is the gang he's trying to get into. Well, that's a recipe for not succeeding. Doesn't mean we don't try. It just doesn't always work.
I hope you all leave today feeling confident that you got some really hardworking, smart people trying to do the right thing in some really delicate, complex situations. If you read the AJC about Judge McBurney, hardest working man in robes, he's working on the election case, the federal case with former president, working on an abortion case. I think what he's one of the more challenging cases was swearing me the superintendent of full-time schools.
I regret it. People say, are there any decisions you make you would undo? There's that one.
But here we are. So if we give a round of applause to
our court reporter.
Thank you so much for your time. Thank you for opening your home to us.
You bet.
We gotta go back. Thank you.
You bet.
Thank you. Thank you.
Hey. Great. I wish we had more time for questions, but it always ends up that way. And I was happy to skip the second plea, but they said, no, do the second plea. So we did that. Yeah, that was an odd one. Thank you, sir. We'll take care. Mr. Hand, you have friends in the group?
Yeah, Dave actually taught at a high school that I attended.
Oh, all right.
And also I did.
Different generation friend.
Yeah, different generation.
Okay. Well, thank you all for lining up, please, so they could see it, and then being here for questions. The timing didn't work out quite right because I know they have more questions. They always have more questions, but I'm glad you guys stuck around. Thank you for doing that. You're off the hook for another year. What did we learn about Mr. Sherman's family, Ms. Evans?
So they told me that they recently, paid for 2 funerals. So it was the brother.
They're not cash rich.
And then over the summer, the father's mother passed. And so they're still paying off for the mother's funeral also. And so basically they're, I think, on they have retirement and Social Security. And so they really don't have a lot of funds right now. So they said, well, they asked for maybe a signature bond. And then if not, maybe 5,000. And even with that, they may have to ask for the 500 from a brother.
Okay. But they think through family support, they could do that.
Yes.
Okay. All right. So I'm not inclined to do a signature bond, given just having heard now a little bit more about Mr. Sherman. There's just a stability question there. And I want to make sure that there's something in the sheriff's bank account that the family is saying, well, wait a minute, you need to go there because we need to be able to get that back. Okay. Well, I'll set a bond in both those cases, and it'll include a requirement that he figure out how to plug into some anger management classes, and that he, in the next couple weeks or after release, get a mental health evaluation and then follow any recommended treatment. It sounds like these are 2 cases that you all are going to be able to resolve, especially now that we've heard from the remaining victims. The sooner we can do that, the better, because it can then get probation, or whatever way you format it, more officially ensuring that the treatment is happening for Mr. Sherman. Sounds like his parents would like him around if they can have the Dr. Jekyll Mr. Sherman around as opposed to the Mr. Hyde Mr. Sherman around. Any conditions you'd want to add? I can't say stay away from the parents. 1, they don't want that, but 2, that would defeat the purpose.
So can we at least add a nonviolent contact?
Yeah.
That's it.
All right, I have to go get on our bench meeting. We're done. I won't see you guys till next week sometime. All right, enjoy. I know you'll be working hard, but enjoy not being stuck in here.
Enjoy the right, sure.
Do what you need to do.
Will do, Judge.
All right.
Thank you, Judge. Judge, did you intend